No, I can't take it. I've already, your turn is already over. You're too senior. You can't mention at the end of the day. You're too senior, mister. You are too senior. You can't mention after that raw junior who mentioned I permitted him as an outside, as a chance for the day. You mention it on the next week. I'll take it up, Mr. Sharad.
Well, there is a recovery notice issued. Otherwise, my lord, I would not have requested.
Ask your junior to mention. Why are you mentioning? Yes. Now, come tomorrow. Come to ask your junior to mention. Why? You need not mention Mr. Sharad for these matters. Give them an opportunity to mention.
They are mentioning because of the recovery notice, my lord. Last week also it was mentioned.
So if it is mentioned last week, I've accepted if I've accepted the mentioning, I will. If I've accepted the mentioning, wait for a while. I'll take it up.
No, last time recovery notice was not there.
Hand over. Yes, call the list. Call the list. Who's item number 1? Who's appearing? Yes. Item number 1. Who's appearing? কি জন্য এসছে?
My lord.
Yes, let the matter go out of
my
the
lord,
list.
My lord, one mentioning, my lord. One mentioning, my lord. Only one, my lord. My lord, on 30th June, my lord, the amnesty scheme for applying for the amnesty scheme will be over, my lord. For that, I am mentioning. I previously mentioned, but it is not appearing.
Number 1, Mr. Mojumdar.
Yes, my lord.
Are you appearing in item number 1?
No, my lord.
Why are you mentioning?
Not item now. One, my lord, not called, my lord. Only consider, my lord, amnesty scheme will be over, my lord, on 30th June, my lord. For this, my lord, kindly Angel Bini, my lord. Only one matter, my lord.
You want to withdraw it? You have instructions with you? নাম নিয়ে নাও। You're Mr. Paul. Mr. Agarwal, learned advocate, appearing.
Item number 2.
Yes.
I am for the petitioner one.
Yes.
But kindly have a look at my last order, my lord.
Yes.
Kindly have a look. Last order, my lord.
Yes. What do you want?
My lord, our reply submitted, my lord. That was not recorded and considered, my lord. Last param.
That previous order was recalled. Argue your matter.
Yes, argued, my lord. But there is direction on the respondent to take instruction, my lord. That although the petitioner seeks challenge adjudication such and such, considering the fact and adjudication of the while passing the order, had not considered the reply petitioner such and such, my lord. Last order, my lord. It is hard, my lord. Last one.
Yes.
We have intimated the department, but till no instruction has been.
Tomorrow, last chance. Day after tomorrow, last chance. Tomorrow is different. Day after tomorrow, last chance. And I will stay everything.
Yes, read petition.
I will stay everything. Please understand, if you don't have instruction, I have now to stay it.
Make it Thursday,
Write a letter to the officer concerned who is not giving you any instruction. Say that the court will stay the order. If he is unable to produce any instructions. Then, so what was he doing? Order was passed on 16th of June.
Read petition file September.
He does not have any instructions in the matter. How will he improve this? How will he improve the case?
They already instructed us to argue on this matter on the.
Naturally, you will never get instructions in such matters. Yes, where is your response to the show cause?
Page 69. My reply, I submitted reply within due time.
Where is DRC 01?
Oh, 01, my lord. 01.
Yes, 63.
Page 63. And
page 63, page 69.
69, my reply, my lord.
Yes.
And their order at, my lord, page 75, operative part, middle portion, my lord. That
What reply did you give? Where is your reply?
reply at my lord 69, my lord.
That is the acknowledgement.
Yes, 70, my lord. And this issue, my lord, I have written categorically that this issue already settled. They issued ASMNT 10, I submit ASMNT 11, they dropped the
No,
case.
70 is not the reply. 70 is the reply.
Yes, my lord. My case is already settled on same self cause of action, same fact. They cannot issue further. The issue already settled.
Where is the 11 July reply?
11 July reply, my lord. Yes. 11.
Where is 70 entirety? Where is page 70 full? With the enclosure. Where is the enclosure to page 70?
Yes, my lord. What number page?
71.
Yes.
No.
Where is the enclosure?
I am coming, my lord. I am coming.
AST1, then where are these documents?
Yes, my lord. I'm showing, my lord. Showing moment, my lord. You do issue settle SMNT 12.
1256.
My lord, 56, my lord, the order of acceptance. I submitted reply 55, my lord. And they accepted, said that the common credit issue matter settled. No further action is required. What happened, my lord? A first audit completed, audit settled. Thereafter, my lord, the officer changed. Then they issued, illegally issued, my lord, ASMNT 10. Again submitted reply. They dropped the matter. Again, officer changed and issued so-called notice on self-same.
Where is the ADT 10 report? Where is that?
Yes, my lord. Yes.
Where is that?
ADT 10, my lord, at page 49, my lord.
Yes?
49. 49 to 50. That audit completed, tax interest paid, issue settled. Audit under section 65, subsection 6, my lord. Edited 2. All the issues
Ashwin.
settled.
Yes, sir.
And my lord,
No, I
ASMNT
said.
10 at page
Yes, sir. What do you have to say to this?
My lord, kindly remand the matter to the.
Why remand now? After I have gone through, why remand?
No, they have challenged that
You have challenged the order.
challenged the order, but the department they have asked to department.
No, your department is sitting tight over the matter. What the department is doing?
No, department has passed the order. They rejected their.
Did not consider his response. Department did not consider his response. Sir, you ought to have come up and said department did not consider his response. Kindly send it back. You chose not to. What did you do? You asked the court. No, nothing is coming. What is this happening, sir?
My lord,
Now the ADT 10 is there.
I know it.
His issues have been settled. Despite that, you have reopened his case.
Kindly make it Wednesday. I will try my best to.
No, sir. Sorry, no more further instructions on this.
and ASMNT 12.
Challenging the order in original dated order set aside, order set aside. Consequentially, ওই ঠিক রিমান্ডের পরে consequentially the order as a sequence, as a sequel thereto, the order passed by the proper officer dated such and such for the assessment year such and such under section 73 of the said act stands set aside.
Period. For the period.
Not tax
Assess- not
period,
Tax.
not assessment year, tax period. Tax July 17 to March 18. Set aside.
And my lord, subject to correction, they will complete the case, my lord, with time frame.
No, not necessary to issue. Yes, next.
Yes, Government Ministers for correction.
Yes.
In para number 3, Lordships, the date it is recorded as 16th May. It is 16th December, the email communication.
Where?
Lordship, para number 3 of your order, Lordship's order dated 16 June. In the internal page 2, an email communication dated 16th May. It should be 16th December, Lordship, page 165 of my petition.
Yes. This matter has been mentioned at the
Lordships, as per the directions passed in the last order, Your Lordship, we have served notice to the respondent number 4, Purti, Your Lordship. We have been communicated by them that they have received the goods. Customs has cooperated. Your
Where is
Lordship,
the
we have-
service.
Your Lordship, this is the service, Your Lordship, and accordingly, we have received a reply. If kindly takes this, Your Lordship, they have received the goods that they had not received from, like it has been transferred. The goods that they had received in a short, Your Lordship. The matter was that they were supposed to receive such good, but wherein
They have received this.
yes, Your Lordship.
Nothing remains in your matter then.
Only issue is like custom does not take any step against me,
No, that I
alleging,
cannot say.
alleging that Your Lordship,
Who is for the customs? That I cannot say.
Your Lordship,
So you see, this is complete.
Your Lordship, then kindly directions for.
If I had
If-
allowed the application on the
Yes, Your
previous
Lordship.
day,
Yes, Your Lordship.
this would have been a double jeopardy. Even subsequently, if the customs detected this issue.
Your Lordship, now the customs has cooperated and they have received the goods, Your Lordship. But I'm just praying that they further do not proceed against us for wrongful
If they
delivery.
proceed, that is not the prayer in the petition.
Your Lordship,
Where is the prayer in the petition? And you did not press that on the last occasion.
Your
You have,
Lordship-
what you have pressed, it is recorded, madam.
yes, Your Lordship. But as they are not appearing, kindly then passes directions for affidavit, Your Lordship.
No, I'll conclude this. Today, Miss I've said so. Now no action has been initiated, no question of passing. Even and when, then you will be liberty to approach this court.
Obliged, Your Lordship.
No action has been initiated. কি বললাম? No action has been, এই একবার পড়ো, no action has been initiated. Passing any orders, passing any preemptive orders, passing any preemptive orders. Full stop. The petitioner shall be, full stop. Yes. Disposed of. এই শোনো।
I'm not hiding. Your lordship kindly takes up reasons of show cause not given to him. That is the we have issued notice for cancel.
It survives whatever effect it is. কে অ্যাপিয়ার করছিল? মেন রিড বেঁচে থাকলো, কে অ্যাপিয়ার করছিল? ঠিক আছে একবার আজকে আসো, মোশন ডাকছো তো? সরি, নট if any mentioning is there, then you come forward. Then I'll hear you. Otherwise, no point hearing you. Only if mentioning today.
My lord, I'm for the petitioner.
Yes.
In this, my lord, my lord, in a brief matter, my lord, there was an assessment under 148 had taken place for a PAN number which was not being used by the petitioner. My lord, the petitioner
Surrender of PAN.
is my lord.
Lord, I have taken the instruction, my lord. It is with me, my lord. If your
You
lordship-
tell me.
Yes, my lord. Regarding new PAN, my lord, they have made certain they have applied for certain correction in the PAN. So, my lord, and thereafter they have themselves applied for new PAN. That is, my lord, my instruction is that without their application, new PAN cannot be issued. In the old PAN, there is a huge demand. In the old PAN, there is a huge demand. So, in try to bypass that, he has applied for new. Well, I have detailed instruction. Lordship will kindly have a look at my
Yes,
instruction.
what he wants to say very well. You
My lord,
please
there
say.
is an order in, when I have got an instruction from the client itself, there is an order in where it says
Because
that,
it says, my lord, regarding.
my lord, this is the order passed by them after we had made an application. My lord, where it says that there was an inadvertent mistake in issuing of both double PAN from the department. My lord, this is the departmental records as per.
Then I'll direct you to cancel the new PAN.
Yes.
My lord, now they have cancelled. After we have filed the read petition, they have.
And proceedings may be initiated in respect of old PAN.
My lord, already
Because they
adjudication
have
order has
huge
been
demand.
passed.
Where? This one.
My lord, this is the order they have given.
Because although the writ petition was filed,
My lord, my prayer is, my lord, let the adjudication
Lordship, item number 2639 of
Where were you doing? What were you doing? Sleeping? Yes? Where were you?
my mother is not
Yes.
well. Sorry.
Call that list. Call that item number.
Item number 2639.
Take it out. Take it out. Take it out.
Sorry. Item number.
Take it out. Yes, Mr. Banerjee.
My lord, in this matter, they have only asked that the reason I said that there is a default fraud and this for cancellation of the.
Where is that?
If your lordship kindly come to his reply, which is at page 17, lordship, P2.
What is the reason?
Lordship. Reason is if your lordship kindly come to page 14.
Page.
Yes, page 14.
Yes.
Lordship,
14 is what?
yes. This is the reason, lordship. This is the recommendation. They want it in. They want this in this page 13.
Absolutely.
I have served both as one show cause along with this recommendation letter. So they want that it should be printed in page 13 instead of page 14.
No. I'll grant you opportunity to appropriately provide them with the show cause. Show cause is incomplete. This show cause is incomplete. This cannot be sustained. Certainly, a question of fraud, I will not let it go. I'll not let it go.
Lordship, no. What
Yes,
usually whenever we have given that detail, this is a copy paste. I can do this there. Now they come up and challenge your recommendation letter, which is the source of your information, that you never disclose.
Correct.
Then we suffer that. And then when we give the notice along with that document that what is the cause against you, then also we are facing this. If your lordship says that I have to copy paste, I will do. Then I
Very well,
again they will say,
I'll treat this as a composite.
yes, composite notice, lordship, because that
No, the suspension will be there. Issue a fresh show cause. I'll set aside this show cause, issue a fresh show cause. I'll permit you to issue a fresh show cause. Because after all, fraud is there.
This is my composite. They can treat this and they have replied actually on that.
So this has to be treated as on this day.
Composite.
If it is to be treated as on this day,
Not as of this date. I served both the two he annexed.
No, the suspension shall not date back. The suspension will be from this date. So I don't want to go that far. I'll give you opportunity. You take steps, whatever you want to do.
But then this is why we made difficult. We tried with this, we copy paste, then say where I have to see. Some court says, then lordship we face this, and when we are giving it show cause along with that recommendation letter, now we are facing. So now whatever lordship will fall from lordship, we will follow that.
No, what is your say? Means of it is registration obtained
Lordship,
by
kindly
means of
see.
fraud.
Lordship, fraud is this.
Why?
that
What is the fraud?
Fraud is he has given me an address that he is operating from this premises. Anti-eviction goes there and find he is not there. So that's the fraud that is in the recommendation letter itself. It is clearly mentioned. Now,
No, you also suspended. Yes, madam. Are you carrying on business?
Yes, the so-called notice does not disclose any specific.
Okay, I have understood all that. Are you carrying on business?
No. Business is not carrying because huge losses.
Your lordship,
You have no right of audience. Yes.
Because business is a huge loss for a big amount.
Lordship, what happens if your lordship takes up item number 15? He carries on from the premises of item number 15. Item number 15, he carries it from his own residence. When we find
Same matter.
connected matter.
Oh, I did. I with item number 15. Wait. I take it up with item number 15. I'll take it up now. So dago pointa dago. You wait here. I'll take it up along with item number 15.
I apologize.
item of
Or already order has been passed.
yes,
Yes.
confused with the item number. I just reached in item of 5.
Or have passed an order already. Who was there?
They are not here.
Someone was represented. Yes, yes. কিছু চারে কি অর্ডার ছিল বলো তো? Yes, what is your contention in that matter?
That matter. As last week I saw instruction.
There is a development, madam. In that matter, the goods have been transferred already with the consent of the customs. So I have disposed of the petition. They wanted to seek further orders, restraining you from taking any action, which I did not say. There is no action, so nothing is there. But it is recorded that you have not appeared.
No, I just reached your item of
Bring her, bring her. Now, call her up and bring her now, so long my officer is here. Otherwise, I cannot record it.
Item number 7.
Some Miss Sarkar was there. ওই ফাইলটা ওকে দিয়ে দাও, ফোন নাম্বারটা নিয়ে নেবে, ফাইলটা দিয়ে দাও বের করে এখনই. So long my officer is here, once the officer changes it will be difficult. Yes,
I'm for the petitioner minutes.
ফাইলটা বের করে দিয়ে দাও. Yes,
I'm for the petitioner minutes. This is matter, they have not followed the principles of natural justice. On the last occasion, my learned senior friend has taken accommodation for taking instructions, my lords.
But his authorized representative appeared for personal hearing.
My
He
lords,
has also signed it.
I'll tell you, my lord.
No.
My lords, give me 2 minutes, my lords. My lords, they
you want to see the signature?
My lords, I'll tell you 2 minutes, my
You
lords.
want to see the
My lords,
signature?
I'll tell you 2 minutes, my lords. My lords, kindly come to my pleadings, my lords. Page number 9, my lords. Point number 17, my lords.
Yes.
They have not issued any personal notice, my lords, personal hearing notice. When we have not received any personal hearing notice, my authorized representative went to the officer. They have asked the certain papers, which we have already emailed to them. Again, we have when they sought for these papers, we have remailed them. That is my annexure number P10, my lords. They have not given any personal notice, my lords. We are not prepared for any personal hearing, my lords. They have not issued any personal hearing. It is when we went to the officer, they have asked for certain papers which we have already mailed on 2 months before. Again, we remailed them. That is my annexure number 10, my lords. That is the pleadings. Also, I have mentioned this particular thing.
The pleadings say otherwise. When a subject to question, my learned friend, he never says that he appeared before the authority. He only says, your lordship kindly looks at paragraph 17 of the writ petition. Your petitioner states that as no notice of personal hearing was received by the petitioner and apprehending the non-receipt of the invoices emailed, the petitioner's authorized representative visited the respondent number 1 and inquired, and on instructions again got the emails relating to the invoices forwarded on 13 to 25 being the email ID of the respondent number 1. He nowhere says that these documents were sought for. He attended personal hearing and he signed on the document of the department. He appeared and he signed. There is no print.
My humble submissions are they have not given any notice for personal hearing. We were not prepared. These documents that were asked for, these were already given much before, my lords. It was given on December 21st. Then, my lords, the same was emailed. My lords, may kindly come to page number 132. I will show, my lords. It has been remailed. As instructed, we are resending the emails, my lords. My lords, these papers also which we have given, they have not relied on these papers and passed the order.
Where is your DRC one?
DRC 1, my lord, is at page 84.
81?
84.
84.
I find it 81. Summary.
my lords. We have replied, my lords. Page number 97, my lords.
Oh, it continues. 84 also. Several. 86.
And there, my lords, on the last occasion, I pointed out there were two notices, my lords. One was draft and one was final. The draft notices were not draft notices were carrying the digital signatures. However, the final notices were not carrying any signatures, my lords.
Anything else?
I rest my submission.
The as noted in the order dated 11 June 2025, the petitioner seeks to challenge the order passed by the respondent number 1 under section 73 of the Central Stroke West Bengal Goods and Services Tax Act 2017, hereinafter referred to said act dated 25th February 2025 for the tax period April to March 2020,
Exactly, my lords, they have not considered.
Yes.
Not, my lords, there is no word where this documents
I
have
have
been
recorded
considered.
your first point was the point which you ought to have come clean. I have not recorded anything there. Had Mr. Siddiqui not been in a position, had his officer not supported him with the document, he would not have been in a position to come. Correct. I will, but I can not go into that. You file it. After all, revenue, sir. I can't stall
They
everything.
have created a huge demand unnecessary without going into the documents. My
If
lords.
you go to
Now,
have
my lords,
succeeded here,
my
I
lords,
would
now,
have
my lords,
allowed
my
it.
humble submissions are this is actually going the normal as
Next. Hey, there are so many matters.
as
Dakota. Yes, have you she's not available. Then I can't change the order. I have passed it in her presence. If you can bring her by 2 also, I'll change that order. Yes, he's here. Madam, the learned advocate for the customs authority is present. Yes, I have you taken any instruction, taken any steps? Sure. এখানে এই লাইনটা ঢুকে দাও আমি ওখানে ঢুকিয়ে দেবো having regard to the fact that no steps have yet been taken by the customs authorities, I am of the view having regard to the fact that no steps have been taken against the petitioner by the customs authorities, at least at least from the submissions made by Ms. Mukherjee, learned advocate for the respondents. No, having regard to the submissions made by Ms. Mukherjee, learned advocate for the respondents, learned advocate for the customs authority, that no steps has been taken against the ওখানে লেখা আছে যে since the customs authority is not represented and I'm able to ascertain বলে ওইখানটা চেঞ্জ হবে
Monthly list,
Item number 12.
item number 12.
Yes, who's appearing?
Millards,
Yes, continue with your matter, sir.
Millards, this is a petition where I have challenged the constitutional bias of section 16(2)(c), and Millards, I have challenged an order in original and a show cause notice. Millards, this is Millards an order passed under section 73 of the Goods and Services Tax Act. Millards, the only reason the demand has been raised is because there's a difference between my GSTR 3B and the supplier's automated GSTR 2A. Millards, it is the contention of the revenue, Millards, that I, as the recipient, should not be able to take credit of the tax not paid by the supplier. Millards, over here, I am forced to challenge the wires, and at this stage, rather than preferring an appeal, is because, Millards, our jurisdictional high court has, through multiple judgments, has held that in case where there's a difference between GSTR,
Have you served?
I have served. I've made all the.
Where is your affidavit of service? Have you served the Attorney General? Sir, what interim order you will get? You've taken such a risk. There is no interim order.
Yes, Millards, there is no scope for interim order. I understand, Millards. But Millards, in this case, Millards, I am the recipient, Millards. There is no investigation conducted against the supplier. there is no case of fraud or
I
willful
will only
mistake.
entertain the petition today. And if you are for
Yes.
the additional solicitor general is appearing in which matter? Same issue. Yes.
There are multiple on petitions.
Yes, which matter? Same issue. No. Oh, that is custom. No, not organic. Challenging the provisions of section 16 within bracket 2 within bracket C of the Central Goods and Service Tax Act stroke West Bengal WB CGST Act 2017 herein after referred to said act as ultra vires. The provisions of ultra vires the constitution.
May be taken because Milaj, this is a proceeding under section 73. It's not the case where there is a willful mistake
For
or
this,
fraud.
for this, I can grant you leave to prefer an appeal which will abide by the result of the writ petition. That I can grant you. If you want.
Milaj, then that portion at
At
least
this
covers
stage,
me. I understand.
at this stage, হ্যাঁ সব হবে না অ্যাপিলেশন কানেক্টেড নয় এটা তো চ্যালেঞ্জ ডিটপিটি এটা ওভার হয়ে গেল এই পার্টটা ওভার হয়ে গেল একটা পার্ট ডাকো
Item number 24.
কি কথা
Application of section 16 subsection. Successful is not functioning. Yes, or it is.
Item number 33.
Yes. Who's appearing in the matter? This has been called on quite few times.
One is appearing.
None appears in support of the writ petition. No accommodation has been sought for. In view thereof, let this matter go out of the list. I'm not dismissing this.
But if you
And especially you see, if whenever someone comes to the court and the matters are dismissed, it becomes very difficult for the petitioner.
One day we might
The government leader is here and I go on dismissing the matter. Shouldn't bear. Usually I don't dismiss matters now.
If the matters are dismissed, my lord, then they will file this application. Or else, my lord, these people, my lord, this is usual practice. We show that the matters are pending before the honorable. Well, but still, my lord.
Dismiss karo dao, dismiss karo dao. None appears.
There is an application for
In view thereof, let the writ petition be dismissed for default.
We do not oppose the restoration application.
That we never.
We never.
Dismissed. Very well. You are saying that once it goes out of the list, they permit it to retain as it is.
Item number 134.
This is that VAT matter wherein the department had given me part interest on the calculation of lordship and recorded on the last day.
Last order কিছু আছে? Huh?
Yes.
This matter, my lord, much has been much has happened in this matter. In fact, the officer was personally asked to personally appear before your lordship. Thereafter, my lord, your lordship wanted us to check the calculation. But on merit, we have a very good case, my lord. I will come to that. But before that, but since possibly this is the first day, my lord, I am getting the right of audience. I was not there before your lordship at your lordship's disposal. But first of all, my lord, the maintainability of this writ petition, that point can always be decided by your lordship at any stage. This
No,
is a
first tell
matter
me.
arising under the VAT Act. Lord, it has to go before the learned tribunal. At that point ought to have been raised by us. Taxation Tribunal Act is there is a complete bar. In fact, my lord,
Why did you not indicate this?
we could not assist your lordship, my lord. But this point we could not assist your lordship.
2024 writ.
Whatever.
2024 this matter was taken and it was fixed for instructions.
This tribunal was. When was it included in the Schedule Act of the tribunal?
It was included as a Schedule Act, my lord, but yes, VAT in the year in 2005 only. Same issue, my lord. The Honorable Division Bench's order. এটা দেখেন এটা তিন একার কপি দেন নাও চাইছে একটাই স্টেট গরিব স্টেট এই ইস্যুটা লেখা
This was from this order.
I can come on merit also.
No, appeal was from this court's order.
Yes, yes. I can come on merit also.
এই order. It's not that I'm judge সাহেবের এই অর্ডারটা ছিল।
Yes. দেখি আমার অর্ডারটা কি ছিল?
No. The forum is that forum shopping हम लोग नहीं
Petition ছিল টু ভোল্টেজ জাস্ট মানে ওই অন্য মামলাটা ইন্টারেস্ট এই
এখানে তো interest. But more or less similar.
Today
Has been regulated. If you want to go before the division bench.
no, Lordship, I am not on that.
323 AB.
On that.
Therefore, my lord, it's also carved.
No, it is regulated.
The extent of the humility. Extent of the powers of the single bench, my lord, taking up.
Yes, regulated.
Sure.
So go before the division bench.
Sure.
Yes, so go before the division bench.
That's why, my lord, it will not.
Power has not been taken away. It has been regulated. Go before the DB.
Lordships.
Either directly or you can, if you want, why will I stop him?
Lordships,
If he wants to go before the directly DB, let him. I can't stop him.
Lordships,
It will not.
Yes. দিতে হবে না, ওই দিতে হবে।
Lordships.
আচ্ছা দাও বইটা দিয়ে দেবো।
Last occasion, when your Lordship directed that 18th of June, they have given me the interest as per them. Today, it was listed for the computation. Last occasion also, Lordship, it was the officer was also there. And 2024, when this matter was first called up. In fact, Lordship, this is a history. Prior to that also, there was a writ petition for representation for the main refund, which was granted. Today, it is only about the balance interest.
But order will be void.
On merit, my lord, I can satisfy your lordship also that. But
Order will be void, my lord, because that will not give jurisdiction, my lord. Single bench in a writ petition doesn't have, my lord, that.
Then,
Grateful.
Yeah, please understand, sir.
Lordship, but this is.
If you want to make submissions, I will hear you.
No, Lordship, there's no point.
But what point
Both
you're trying
times
to make,
precious,
I'm trying to understand that. But I have certain limitations.
Lordship,
That's the problem.
Although এটাকে না এর সঙ্গে দিয়ে দিও, ওটা বেরিয়ে না যায় এই অর্ডারটা। Yes. Both Mr. Mojumdar and the government pleader are nowadays not to be found here. Both Mr. Mojumdar and the government pleader are usually not to be found before this court.
But I am mostly on the,
Well, you are always there,
the problem is
My lord, I
but Mr. Mojumdar is not available.
Mr. Mujumdar has better pastures.
Yes, yes. Yes,
Well, I
Mr.
tell you, Lordship,
Most of the time.
well, I tell you, Lordship, well, one thing which has happened that's very good for the profession and for the members of the bar. The current generation, the new generation, that is the generation just, my lord, who are now 40, 45, they are extremely good.
Yes, yes.
They are extremely good. So, my lord, the question arises that if the clients can rate the same results with them, why will the client
Profession
rate
should always be opened up to give opportunity
Yeah,
to the
obviously,
members of the bar.
and this is the best
And there
thing
are
to
so
happen.
many matters, so
The
many
best thing to
matters.
happen. This is the best thing to happen.
See, at the end of the day, if you move around the High Court,
Yes.
considering whosoever is there, only a handful number of arguing counsels are
Right. That's
And I'd rather join issue with Mr. Mujumdar. It's not limited to 40, 45.
30. No, I new.
Yes,
30,
yes.
that's
And I'll tell you,
the number. That's the number.
advocates coming on to practice within a year or so, and I have seen advocates moving matters just within a year before this court, not moving with the confidence
They are
and
good,
getting
they are good,
orders.
They are good. They are good. They are good. They are good. They are definitely.
And
5, 6 years into the profession, I put shaking on my legs.
no, that
So, my
situation
lord,
has changed.
I now travel to other courts, other determinations.
Better pastures, I say.
Yes, Mr. Wali.
But may I take your lordship? But we are in this petition challenging an order in original.
This matter was heard
Yes.
on 15th May.
Yes.
This is that Manipal Hospital matter. no?
Manipal Hospital. This is MRI, my lord. This is the MRI, which is now Manipal. But the core issue which arises, but subject to your lordship's consideration.
No, this was fixed on 19th
19.
at 2 p.m. এই কি হলো এটা 2
It was not there. It was not there in the list. So it has come up.
এই এটা এরম ভাবে এলো কেন? এই মামলাটা এটা তো 2 p.m. এর ফিক্স করা মামলা।
2 p.m. fixed.
Yes, yes.
It was fixed at 2 p.m.
ফিক্স করা মামলা।
But it did not come up on that day.
এটা তো সময় লাগবে, এটা তো শেষ করতে হবে, নাহলে আরগুলো আটকে যাবে। না এরম ভাবে তুমি দিলে 19th ছিল লিস্টে মামলা না।
But it was not marked as 2 p.m. matter on 19th. It was not marked as 2 p.m. matter on 19th. But I understand, my lord, what we. Yes, my lord. My lord, the otherwise, my lord, recovery proceedings would be initiated. Let that be the understanding. But if that is the understanding, man. Kindly fix it on any day, my lord.
Indeed, nothing has been issued by the department for recovery.
First July. Well, kindly give me 1 second.
Second July, you will be traveling to 58.
The evening में जाएंगे ना. Your lordship is posting this matter at 2 p.m. First July. Well, 3 p.m. will be slightly difficult for me because, my lord, I may have to take, I will be traveling on 2nd July in the evening. So, my lord, I have to, my lord, that's my personal difficulty, obviously, my lord. That's. But 1st July is not possible.
Oh, I see. Then 2nd July, 12:45. 12:45. No, your lordship has, Mr. Bhattacharya is there, and we know much. Yes, yes. Nothing.
If anything happens now, yes, on his control, what will you? Then the department. Or that do not come and say that despite him giving an accurate.
No, that I will never. Malad,
Maybe things which are beyond this.
which are, Malad, we don't know what is happening right now. We don't know what is happening right now.
At least today, Malad.
Malad, I will never take that plea that despite action. No. Then it will be an argument on merit that this could not have been done. Right.
Appear in the daily list. Daily list.
Item 1122. Wait, please, man. This is that Provident Fund matter where my lord had appointed my learned senior to take instructions on behalf of the Provident Fund Authority, whether I am registered with the Provident Fund Authority. But the issue was that the notification, my lord will take my lord's order dated 23rd April. 23rd April, my lord, I recorded everything, my lord. 23rd April 2025. But 26th March, my lord. I'm sorry, my lord. 26th March order, my lord.
Yes, my lord. Exemption is still continuing, my lord, under section 17 of the Act. Exemption is still continuing under section 17 of the Act. Meghna Mills initially that was Meghna Mills. Thereafter name has been changed. My lord, that is not initially which was notified. Yes, my lord. Yes, my lord.
Has been granted exemption.
Yes, my lord.
Will it extend to I? Though technical, but after exemption, since the name was changed,
Yes, my lord.
can we trust the change also?
$57.
That will be 57.
That was 57.
Yes. No, my lord, that is there, my lord. Correction is there.
instruction, whether exemption is still continuing or not, and under which section, section 17, my lord knows very well, my lord, exemption was granted, and that is, yes, my lord, Meghna Mills. That I can't say at this stage. That is,
The Meghna Mills company was the name of the factory. And my lord, once my lord finish, I'll just point out certain things in the supplementary affidavit. My lord, there's a supplementary, my lord, on record, my lord. My lord, if my lord will take page 20, at page 21, so Prithu was appearing, my lord, Mr. Prithu Dudoria was appearing, my lord.
supplementary affidavit.
Service question. My lord, this I've taken out from the web on today, my lord, last day's date. My lord, at page 20, at running page 21, my lord will kindly see serial number 725.
Copy of read petition is with me. My lord, kindly.
I'll give you, sir.
Yes. My lord, kindly pass a specific order what my lord want to know. I shall specific order to that extent I shall obtain. Kindly mention in the order. Yes, sir. Yes, my lord. Yes. Yes, my lord. Yes. Yes. Yes, my lord. Mills.
Meghna Jute Mills.
Yes, my lord. That is notified. Meghna Mills. Company Limited. Company Limited. Yes, sir. Yes. And accordingly, deed of trust duly sanctioned under section 2E or something of the Income Tax Act. And thereafter, my lord, if such changes, no, that's why I am saying. If thereafter, if changes has been given, name has been changed, trust shall also be changed accordingly under the act, and that must be approved by. That I can't say, my lord. Further notification, further name has been changed and notification has been issued to that. Should be there, my lord. If a name has been changed, trust shall also be changed accordingly.
That is there on record, my lord. The income tax recognition of my lord, I understood. I've understood. My lord, I have understood, my lord. I have placed those documents. My department is also not disputing that fact. And my lord, on today's date, I'll show, my lord, my number. My lord, on today's date, they are denying me the benefit only by seeking that during the intervening period, I had to register myself with the income tax authority by making a fresh application. That I did not do. I am saying you have all throughout treated me like a trust and you have exempted me. You have never raised any dispute. I am coming, my lord, that assessment order has also allowed most of the demands, but has disallowed only on the aspect where it is coming under the provident fund.
Jagaddal.
Jagaddal.
Jagaddal. 24 Pargana. Barrackpur. Jagaddal, 24 Pargana.
My lord, just my lord, my lord.
Yes, two factory.
No, Jagaddal. No, Jagaddal West Ghoshpara. Now they are adjacent, my lord. Out here it's given two, but my lord, this relates to Jagaddal West. I know. My lord. My lord.
17th October, this notification was there.
My lord.
Serial number 14 and 15 are
My lord.
Yes, two.
My lord.
14 and 15.
Well, it will be serial number 14 because serial number 15 relates to East Ghoshpara. I am West Ghoshpara. This is 14. I am 14. My. Chagaddar. My lord, my lord. My lord. My lord. Show me that intimation, my lord, is not there, but the change of name is there in the writ. My lord, it is by a proper deed, my lord. We have annexed that deed. Deed of variance was issued, my lord. Writ petition, page 18. No, my lord, taken over. It is not taken over, my lord. The name has been changed to Meghna Jute Mills Provident Fund. My lord. My lord. No, my lord. Change of name does not incorporate new certificate of incorporation. It is a change of name. Incorporation, man, is a change of names. Notification will be yes. Certificate of incorporation. Change of name certificate issue. Certificate of incorporation बोलेगा. My change, my deed is at page 18 of the writ petition. My lord, can you see this supplementary once? My lord, finish this. My lord, then my lord will see the notification. My lord, the website copy current. My lord will kindly see at page 20 at page 21. Serial number 725. Now, this is the current website copy. From the website, I have taken this printout, my lord, of Provident Fund Authorities, page 21, serial number 725.
Page 21.
1. My lord will kindly note the number 35000. Page 21, my lord. 725. Serial number 725, my lord will kindly see Meghna Jute Mills.
725. Yes.
And my lord will kindly see, yes, this is the current website printout. My lord will kindly see note the number 35000 towards the end. No, my lord will kindly see. My lord, one more thing, my lord, the audited balance sheet of the current year and the relevant financial year I'll show.
When my lord listed?
It will come up in July. We'll give a, my lord will on a, how much time for affidavit? How much time for the affidavit, my lord?
Fifth, my lord,
Please, item number 38.
May I please your lordship?
My lord, I appear for the Union of India.
My clients imported bed sheet. The authorities raised an issue. I'll take your lordship to the paper. The authorities raised a issue relating to the classification of these imported goods. Now, I was claiming these goods to be.
Where is the order?
Well, it's not an order. It's not. Now, they issued a show cause notice. I gave a reply. I gave also, submitted also notes of submission. The initial adjudication order went against me. To an extent, department was also not satisfied with that order.
Where is that order?
I'll place them. Now they preferred an appeal. Now, in the appeal, your lordship would kindly come P2, annexure P2 119.
Yes.
Now, this is the order of the tribunal.
Yes.
By which is your lordship at page 119? Now, the opening paragraph would suggest the facts of the case are that the
From says that they have to approach the division bench. I cannot clear out.
I'm not, it's not that also. Let me just.
Yes.
Now, my lord, this appeal was decided in a way the tariff head which I was seeking for, the tribunal has held in my favor. Now, if your lordship kindly comes to Malad takes paragraph 5, that would clear the whole thing. In this case, the claim of the respondent, that is myself, is that they have correctly classified the imported goods as 100% polyester bed cover, oblique quill cover, having merit classification under CTH 6304. This is what I was opting of the customs tariff. The same issue came up before this tribunal in the case of Commissioner of Customs Port, Kolkata versus Shilpa Fine West Private Limited. Final order is there, wherein the tribunal has examined the issue and observed as under. Then, my lord, paragraph 5.1. As we are of the view that the respondent imported bedsheet which are having merit classification under CTH 6304 of the customs tariff. In these circumstances, the charge of suppression of fact is not sustainable against the respondent. Therefore, we do not find any merit in the appeal filed by the revenue. Accordingly, the same is dismissed. Now, my lord, after this is passed, I go before the authority. I say, since now the tribunal has held that whatever I declared, the tariff head, the goods merit classification under that tariff head, kindly now assess my bill of entry and take the duty and release my goods. Well, they maintain a sign. After this order, classification has been done. I say, classify my goods. And the head, as directed, held by the tribunal.
Where is that application?
My bill of entry is already there.
They ought to have concluded that.
My bill of entry is already there. Only thing, I have to give a letter that now the tribunal has.
Where is your letter?
I'm just showing.
Yes.
Now I go on giving them letter. Maladu gets it from 123. Malad from 123 till 137, all letters. Malad, I'll just give your lordship the dates. I'll just show one letter.
Yes, not necessary. I've seen. Yes, madam.
It's not the end. Then they do not do anything. Then I ask my container agent where the goods were.
that kindly give me a physical inspection of the goods.
Yes.
Because the goods are lying with the customs under
Yes.
detention.
Yes.
Now my lord would get surprised. Page 152. My lord, to Container Corporation, page 152, your lordship sees my
Yes.
letter. This is to request you to allow us to inspect our goods lying at your CFS terminal. Vide above said bill of entries as per the order passed by the customs tribunal, we have been allowed to clear the goods from your terminal on payment of duty. So please allow us, our representative, to inspect the goods under the above said.
Yes. What happened to this?
Now, my lord, would kindly see the 3-line note at the bottom.
Which page?
Same page. The Container Corporation is now writing to me in the same letter. As per your letter and our record, we find all consignment were auctioned on 13/11/2020 by customs. 13/11/2020. Now, my lord, would come back to page 119.
Not necessary.
My
You
lord,
see,
there
you
only
see,
thing I want to submit.
you see,
They filed an appeal 2018, which your lordship gets
yes.
page 119.
They have to produce the records. What interim order you will get? That does not matter. Whatever appeal.
Because
This is a question of, he is alleging question of fraud today on you. I am trying to say, make out a case that notwithstanding there being no direction issued on you, they have done so. Produce the records first of all to show their communication. Later A. In a position to prima facie demonstrate that the matter ends, then they have a recourse. But if you are not in a position to demonstrate that, then the consequences thereof would follow. And what is the sale price?
My lord, I do not want sale price.
No. What is the sale price of this?
This is the value they should return me.
Yes. No. Minus the sale price. Minus the sale price. Minus the sale price. They have some amount they are lying with them. So that amount and the difference they will return you. But today it is premature to say all this. The question that has arisen for consideration in the present writ petition is whether question focus. The petitioner claims to have imported
Bed sheets.
both petitioners are, who are they? They are the, who has imported, both the petitioner.
They are partners.
Partnership firm's name?
I've given it for Kulab Jalan and another.
The petitioners as partners of Messrs. Steel Syndicate had imported polyester bed sheets, no?
Yes.
Which paragraph you have said so?
Page 119.
No, paragraph petition. Had imported 3 consignments of 100% polyester bed sheet, polyester bed cover, stroke quilt cover. First up, according to the petitioners, since they were not aware of the exact classification of the goods, they were unable to self-assess the goods and had accordingly approached the department to examine the goods first on within inverted quotes, first check inverted quote closed basis, and to assess the bill of entry provisionally under section 18 within bracket 1 of the Customs Act 1962, hereinafter referred to the said act. the particulars of the bill of entry would, however, indicate that the classification has been made under CTR 63041990 on the basis of their understanding. Records would reveal that a show cause cum demand notice was issued on 5th August 2017 proposing classification of the goods under CTH 54075,490 along with a demand of rupees 165,99,624 on account of duty full stop. Said show cause was issued under section 28 within bracket 4 of the said act which inter alia also provided for confiscation under section 111 show cause for confiscation or
This is show cause proposal.
Achha. The said show cause also proposed confiscation under section 111 within bracket M and penalty under section 112 within bracket A stroke 114 capital A of the said act. Eta na page number 5 e pabe.
My lord, order in original at paragraph 10.
This followed an order in original dated 29th November 2017. Full stop. The department being aggrieved had preferred an appeal before the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, within bracket Sestat.
Paragraph 11.
Full stop. By an order dated 22nd March 2024. The Sestat was of the view that since the petitioner had imported bed sheets the classification under CTH 6304 of the Customs Tariff Act was justified, and as such, the charge of suppression of fact was not sustainable. In furtherance to the efforts of the petitioners had from time to time, by several letters, interiorly including the letter dated 16th April 2024, had requested the appropriate authorities to release the detained consignment. Full stop. Such communications having failed to yield any result, the petitioners had subsequently sought for inspection of the aforesaid goods which were detained which had been detained and had been retained and had been retained with the Container Corporation of India Limited within bracket Concord. Full stop. On such representation being addressed to the Container Corporation of India dated 2nd December 2024, the petitioner had been intimated by the Container Corporation of India Limited that as per the records available with them, on the basis of the petitioner's written request, the consignment has been auctioned on 13th January.
My request.
Yes, on your request.
On my request, they inform me as per your letter and our record, we find all consignment was auctioned on 13/11/2020. It is
Say no, no.
they inform me the fact.
আচ্ছা কি বললাম? As per records available with them, no, as per records available with them, the consignment has been auctioned on 13th November 2020. Full stop. This has come to the petitioner as a surprise. Full stop. Which paragraphs you have said? This has come to you as a surprise. Mr. Mukherjee, learned advocate, representing the petitioner, would submit that this has come to the petitioner as a surprise. তারপরে বলো কোথায়? Paragraph is there.
I have said illegally sold. Your lordship comes to paragraph 25.
Full stop. No authorization had been given by the petitioner, by the petitioners. At least the petitioners were never kept informed with regard to the aforesaid development. Full stop.
Was sold while the appeal was pending before the sestat. At least the appellate authority ought to have been informed that we are selling these.
The petitioners are yet. Full stop. Yet. In the circumstances as aforesaid, the present writ petition has been filed. Mr. Ms. Mukherjee appears on behalf of the Customs Authority, for having regard to the peculiar facts made out. I am of the view that the entire records of the case should be placed before this court on the returnable date. Full stop. I am of the view not only the entire records of this case should be placed before this court on the returnable date, but the respondent number two, 3, 4, and 5. But the respondent numbers 2, 3, and 4, as also the respondent number 5. Now, 2, 3, and 4. 2, 3, and 4 should file a report in the form of an affidavit disclosing the circumstances under which the consignment comprising of the goods forming subject matter of the 3 bill of entries numbers 938334, 938333 and 938331. 938331. Please wait. 938331. All dated 20th April 2017. এবার লাইনটা কেটে গেল প্রথম দিকে, বলো তো পড়ে কি বলতে বলবে?
I was only trying to assist your lordship. Page 153 has it.
234 should file a report in the form of affidavit such and such has been auctioned if at all. Has been auctioned if at all. If at all. I am not sure. You are not sure. I will not go by.
My container agent says so.
He may be wrong.
No,
He may be wrong.
the container agent cannot go wrong.
How?
My goods are in the container. Whom I have paid the rate.
Then
for
you
the
have to catch hold of the container agent.
The
First this comes, then after once their record shows, no, there is no such direction. then the container agent has to be brought in court.
Just under the order of the customs, it has been done. And I'll show the law. What is the law?
So have you disclosed any order?
The law I will show what is how these goods are to be dealt with while it is under detention with the customs and an appeal is pending. They cannot auction these goods without intimating the appellate authority. I'll show that is the law. They are
Let
the
them
customers.
calmly stand, let them find a
I was just praying. Your Lordship,
Is this matter for
this
further
is a
consideration under the same heading in the monthly list of monthly list of next monthly list? They have to have some time. Monthly list, next monthly list. Hurry, Miss Mukherjee, 7 days time.
I appear for the Union of India, my lord.
Unless it is in the top, it will not reach. Top money group 1. Group 1 will take some time to reach. Upore affidavit of service filed in court. তারপরে দেবে, হ্যাঁ, it will appear after some matters.
Item number 43.
Deeply obliged.
Yes, give your appearance on the chat box.
My lord, my lord,
এই chat box থেকে appearance নিয়ে নিও।
my lord. Deeply obliged, my lord.
My lord, this is the
Hey.
evidence. It also read. My lord, this is under Central Sales Tax Act. The matter actually whether we have received the C forms, E1 forms, and E2 forms. In the C, central forms, exempted sales, E1, and thereafter E2 forms. This is the primary challenge here. In the appellate stage, we produced some forms and thereafter we collected other forms that we have in the revision application we have duly submitted that we have collected other forms. Revisional order. Last. Passed by board.
Divisional board.
Divisional board.
At page 50, 50.
50.
This is the commercial taxes appellate. Last.
The authority is passing contradictory order, my lord. At para number 1, my lord. Not para, just point number 1. There is something. Yes, my lord. That is the last of the. Sometimes one member seat also sit. It a boarded, not first.
Then the application member has to find out the judicial member before when subject to question before the tribunal. And not
In board there is one judicial member. Yes, ma'am. My lord, there is.
Oh, back act. CST act.
But board, it is the constitution of the board.
The appellate board comprises of 2 members. One judicial member, one of the
My lord. There undoubtedly there is one judicial member.
It will lie from this order.
Yes. I read with. No doubt.
It will lie.
Not the issue.
Central আচ্ছা এই দেখো না ভ্যাটের বই আছে 87
Section 87 of the VAT Act. My lord. Now the board, my lord, the
Board.
board takes into consideration both central sales tax and the VAT Act.
section 87 we filed the revision application before the board section 87 82
দে না আরে বসে আছি কেন নতুনটা দে না নতুনটা দাও না সে ব্যাটে
আরে অর্ডারটা ডিফেক্টিভ করে ব্যাক করে দেবো সুবিধা হচ্ছে
Appellate and Revisional Board is defined in section 7.
Section 7. Of the VAT Act. VAT Act. Shall appoint such number of members of the appellate. Shall appoint one of the members of the appellate.
One member.
No, my lord, at 6.
Section, subsection 5. The functions of the appellate and revisional board may be discharged by any of the members sitting either singly or in benches of 2 or more members as may be determined by the president. So, the president made this case, and that is not his case also. That is not his case. So one can sit singly also. So, division benches, but the decision is not in.
They are the majority.
In case of other benches, under subsection 6, if members of a bench are divided, the decision shall be the decision of the majority, if there be a majority. But if the members are equally divided, they shall state the point of points on which they differ, and the case shall be referred by the president for hearing. So there is division benches also. There is single bench also. In terms of subsection 5, there is a single bench also. That can be a single.
There may be. Our grievance is not there, my lord. At point number 1 of page 50, my lord. See, my lord, his declaration forms C, E1, E2 were not considered and allowed. Were not considered and allowed. So at para number 1, he is writing this. Then in the middle, at this stage, the petitioner was given 4 opportunities to produce the declaration forms. However, on the last hearing date, on 19/11/2024, learned advocate submitted the where we have submitted. We have never submitted like this. In the petition, we have submitted. In the revision application, we have submitted. We have collected all the forms. Kindly, my lord. My lord, kindly turn to page 45. My lord, yes, my lord. Yes, my lord.
Yes, he got it his contention in serial number 1 and 2. That is his contention.
His contention.
As per the
the next line is the
My lord.
Petitioner was given 4 opportunities.
My lord, undoubtedly. My lord, come to page 45. My lord, kindly.
not submit the declaration forms.
My lord, kindly come to page 45. This is my revision application. This is the grounds. My lord, Para 5. For that petitioner craves leave to produce declaration from C, E1, E2 in support of his claim. My lord, I am.
You produced it here in the repetition.
My lord, I have all that. No, not in the read petition.
You don't have it.
He craved leave. He did not produce it. 4 opportunities were given to him.
As of today also you have not produced it.
My lord, in that case, kindly grant me the leave. I will produce it before your lordship by supplementary affidavit.
Advocate representing the petitioner seeks leave to file a supplementary affidavit. Yes. বইটা ফেরত দিয়ে দাও।
Item number
না,
43.
একটা লাইন হবে। Stand adjourned. The petitioner shall be at liberty to file বলেছি the August the petitioner shall be at liberty to use a supplementary affidavit enclosing therewith the relevant forms with an advance copy to the learned advocate for the respondent. Full stop. Inspection shall also be offered of the originals if sought for by the learned advocate. You can also seek inspection and write letters if necessary once you get it. Because I will not decide this at the end. Call the list.
Item number 46.
Your Lordship, I appear for the petitioner. In this matter, I am being led by Mr. Praneeth Bag. He's on his legs. May I pray for a short passover?
Appellate order.
Not this week.
আগের বড় সেই ইন্টারেস্টিং পয়েন্ট বলে
Vote that.
Item number 47.
For the petitioner, my lord. ওরে তো আচ্ছা
My lord, I am praying for not this week.
Yes, sir. What is the matter?
matter my lord, PGST was imposed in a municipal bill, my lord. And my lord, work order was issued prior to implementation of GST, my lord. And my lord, work was completed prior to the implementation of GST. But my lord, billing authority, my lord, Haldia Municipal Corporation, my lord, development authority, my lord, wrongly, my lord, imposed, my lord, GST at the rate of 6%. My lord, against that, my lord, representation was made and a writ application was filed before this honorable court. Honorable Justice, my lord, Nijamuddin, my lord, was pleased to pass an order directing the authorities to consider the matter and by giving an opportunity of hearing, my lord. After hearing, my lord, Haldia Development Authority found that they have wrongly imposed the GST and they have my lord, passed an order, my lord. My lord, kindly come to my lord order.
Page 54.
P9, page 59.
My lord, relevant portion, my lord, page 54, my lord.
You deposited this GST?
Lordship?
Yes.
Lordship. My lord, and but my lord, according to them, they are not the my lord disbursing authority of the GST amount which I have already my lord deposited due to
Deposited?
the Lordships.
You deposited?
Lordships. Now my lord, that has to my lord refund, my lord. Receipt is my lord here.
31st July.
Yeah, yes, my lord.
Apply for refund.
My lord, then my lord, allow me to apply and my lord, let they.
His prayer is he has to apply before the authority. That is his prayer only.
Two year is over.
No, that is, my lord, Haldia has to, whoever, my lord, Haldia has to pay. GST has to be levied. Whoever is to pay. My lord, his prayer is against the Haldia Development Authority. Kindly see.
No, my lord.
Haldia Development Authority has. Kindly see the prayers.
My lord, there may be.
It is not against the GST authorities.
My lord, kindly.
Court cannot pass such an order. Can the court direct Haldia to pay GST?
No, that is his prayer.
He may be writing so many things, Mr. Chakraborty. Will the court go by him?
I have been taught, my lord, only the case made out in the writ petition.
a third party case. That is what I have learned, my lord. My lord,
His case, he's arguing this case.
my lord, his case is consideration of representation. Kindly see.
Haldia has considered his representation. Court will, Mr. Chakraborty, the court is not going to pass such an order which is contrary to law.
My lord,
Can never pass such an order.
My lord, deepest respect, there has to be levy of tax. GST, I am entitled, GST authority is entitled. Whoever is paid.
And you reject his application if he allows.
My lord, he has to take the money from him. That is his case. My lord,
No,
that
no,
is his case. The
forget about.
My lord, who is liable to pay the GST? Who is liable?
The
He is saying
construction was completed before that date. The
Payment
bills were raised before that date. Section 11 and 12 comes into play of the GST Act. Show me from sections 11 and 12. What are you saying, Mr. Chakru?
Section 9 first.
Relevant time is the time of supply. So 12 and 13. Time of supply. Time of supply is before the GST Act. Did you deposit GST?
Yes, my lord. Page 36, my lord. That amount is asked to me, my lord, refund, my lord.
Correct.
My lord, with interest, my lord. I think.
And if it is refunded, it will be refunded along with interest.
Let my lord. I am praying for an order, my lord.
My lord,
Allow me to file.
I am praying for not
Who
this
are you? Who are you? Not this week. Who are you?
on behalf of respondent number 7 and 8.
Haldia. তোমার বলার কি আছে?
Yes, Mr. Chakraborty. Page 36.
Stolen mine to it will appear.
আমরা রেখেছি দিয়ে কি করেছিস বলতো তুই?
Page 56, kindly see. But that is his representation he has made before the concerned
So
authority.
details of deposit is 1 lakh, no, 19 lakhs.
19 lakhs, my lord.
19 lakhs GST has been paid. Wrongly paid.
Sorry.
Wrongly paid because of Haldia.
Lordship.
He has been fighting tooth and nail.
My lord, kindly see 56. My lord,
Yes.
you kindly see what he says.
My lord, there may be, my lord.
আরে বলতে দেবে
বুঝতে পেরেছি আপনি যা বলতে।
Yes.
This is to us, my lord, not to us. He has come for
And he is not asking representation consideration by you, nor will I direct. Nor will I direct. If he asks for something, how can you object to him applying for refund in accordance with law?
I am not saying, my lord would kindly appreciate this. My lord, I am entitled as a taxing authority. I am entitled to get tax.
You decide it.
No.
You decide when an application is made. I will not entertain his application on this ground.
But my lord, with deepest respect, he says, I have wrongly paid the liabilities with the Haldia Development Authority. That is his case. That is his case. He says, I have wrongly paid to the GST.
You reject it. So you reject it. Who is stopping you from rejecting, Mr. Chakraborty? Your officer has to pass an order and reject it.
But after 2 years, my lord,
That part I will give him that
No, my lord,
direction. Yes.
my lord, there cannot be anything contrary to law, my lord. My lord, with deepest respect, any consideration has to be in accordance with
Where is
law.
your case that Haldia had directed you to pay deposit the GST?
My lord, kindly come page 54, my lord. Haldia decided that wrong.
Forget decision.
They have wrongly.
Previous order by Justice Nizamuddin. Yes.
So P9, first one. P9.
President consideration.
No. Order. Justice Nizamuddin order.
Ito.
Page number 50, Your Lordship.
Now, coordinate bank was taking up matters under Group 4, not under Group any other Group 9. This order has been passed under Group 4, where you were a party. Amit Kumar Nag and Ranjabati Roy had appeared. 2024, passed under Group. In the writ petition, the GST authority was a party.
Yes, ma'am.
Why are not they appearing? They are not appearing here. They are not appearing here. Found out from Sharthok. Just open from Sharthok. WPA 3218. Find from Sharthok.
The previous occasion also respondent number 8 was, my lord, it would be clear for the whole year development authority.
See,
Page 53.
no, just find out whether your
No,
party.
order is there, my lord, 53. Kindly see. Order, he says, I am acting in terms of the order passed by the 53.
That order is at page number 50. High Court's order is 50.
No, 53. Kindly see just.
I will go there.
50 is the order sheet from the earlier development authority.
53. Kindly see the first 3 lines. Chartok ke nahi, the state party. It is not there in Chartok. State was not a party. And that's why respondent number 8 is development authority. They had passed this order.
This writ petition was where is annexed P4?
P4 এখানটা দেখুন P4 is page 31 to 33, your lordship. 31 to 33.
So they have deducted TDS as GST.
Lordships.
Yes. Yes, sir. No wonder Mr. Chakraborty is shouting.
Well, actually, the GST amount had already been deposited under the GST.
Who has deposited it?
In drawing senior, my sister.
Who has deposited it?
The petitioner has deposited, my lord.
Who has deposited?
Petitioner, my lord. According
Where? Come to page number 31. Mr. Chakraborty, come to page number 31.
Next chapter.
31.
ঠিক আছে আমি দেখি
দেখি আমরা
repeat the
Yes.
Well, kindly see kindly see page 36, my lord. In
payment
total payment receipt, my lord. Through made by made a mode of payment NEFT RTGS, my lord.
Correct. So you were not released this amount. Yes, who is appearing for Holdia?
Solen Kumar Maiti.
Who is appearing?
I am appearing. Learned advocate Solen Kumar Maiti.
Where is he?
He is not well today.
challenging the order two times. He is not well. Your learned friend is not well. He cannot come to court. What will happen if I even place the matter on a particular date? He does not know whatever is there in the matter. I'll place it. I'll take it up. But
If your lordship kindly permit, my lord, I want to withdraw this matter.
which matter?
It is not in the list, my lord.
I cannot permit withdrawal.
Not, my lord. If your lordship kindly permit, keep the matter tomorrow under the heading to be mentioned, my lord.
Call one more matter.
My lord, I'm extremely clear.
Praying for not today on behalf of Mr. P.L. Gupta, my lord. Not I am praying a not
Louder,
today.
louder.
I am praying a not today on behalf of Mr. P.L. Gupta, my lord.
Not this week. Not the action. After 1 week করে দাও Wednesday week. এর মধ্যে ডেকো না 30 তারিখ নয় 2 তারিখের আগে ডেকো না। Yes, this is call being called second time. তাহলেও দিয়ে দিও, go out করে দিল। No. Since an accommodation has been sought for, no. This matter was called on previously, however, was not taken up since the petitioner was not represented. Full stop. আগের দিন ছিল না তো petitioner, right? Full stop. Today, at the time of call, an accommodation has been sought for. Full stop. In view thereof, let this matter go out of the list. Next. Next. It will take some time. I come after the lunch.
Yes, yes, ma'am.
আমরা কিন্তু ব্রিফ পাই, আমরা কিন্তু ব্রিফ পাই, সেন্ট্রাল পেজ স্টেট পাই।
I come back after the lunch.
For the respondent.
Yes, sector is the
Yes, sir.
My lord, I am the manpower supply business. I am the petitioner. I am providing service to the body corporate.
Yes, yes.
I am the service provider of manpower supply. So I am providing the service to the body corporate. They are covered under RCM
You are providing services to the
to the body corporate.
body corporate. Very well.
They are pay the tax on behalf of the service provider. RCM. Enter procedure covered by reverse charge mechanism.
I see.
So
that is spelled
without
out.
representation.
That is spelled out in the contract itself.
Yes, my lord.
But you have been issued a notice under section 73.
After receiving the notice, I represented the department as per the all papers I submitted, but without considering the fact, they passed the demand order against me.
Where is the order?
Kindly look into the page.
Where is the show cause? Where is your reply? Where is the order?
Yes, my lord. Page 49 of the writ petition, my lord. Annexure P8, page 49.
What is that?
This is the impugned demand order, assessment order.
Where is the show cause and where is the reply?
Yes. I received the show cause notice on annexure P6, page 34, my lord. Yes, pardon me, my lord, page 19. They send a email. They
Where is the show cause? You have not annexed it. Yes. Very well. Where is your response?
this is a response. So called page 34, my lord.
You have said that you did not receive the show cause.
First, they send me an email. So the email containing some reference of show cause notice, but I never received that show cause notice. I categorically mentioned in the department. Thereafter, repeated request, they issue a fresh show cause notice.
Where is that?
In the time of personal hearing, they just show me the show cause notice.
Showed you the show cause notice?
No.
Only showed you the show cause notice?
Copy
was not given to you?
No. I categorically mention in my abutment writ petition. Date nil. In the page 3 of the writ petition, paragraph 3. They just cited a reference to my, in my email. I had sent you the so-called notice, but there is no date, nothing I received from the respondent authority.
You are a registered taxpayer.
Yes, my lord.
You have access to portal.
Yes, my lord. Access
In the portal also it was not there.
No. They only sent a personal hearing notice. I appeared in the personal hearing. They are on that date, superintendent officer was not absent.
Where is your case of reverse charge mechanism?
Reverse charge mechanism.
Which paragraph?
In their assessment order, my lord, demand notice come assessment order.
Why have you annexed these two notifications of 2015?
I annexed the notification.
Why? Which paragraph of the notification is relevant, sir?
Yes, my lord.
Page 30 notification, which is relevant? এই এগুলো দাও তো আমাকে।
Sir, page 27, my lord.
এগুলো তোমরা দেখে রাখবে তো আছে কি নেই দেখে রাখবে তো টেবিল
Serial number 8 of the notification.
Page
32, serial number 8.
Page 32. Supply me. Yes, supply me.
Supply of manpower.
Supply me, PD page 32. I don't have it.
Page 32 of
Yes, supply me a copy of page 32. I don't have it. What? Yes, supply me now.
Yes.
You have a copy of page 32?
Yes. Yes. This is the first notification. Thereafter, they amended and they increased the 100% service tax will be paid by the recipient on behalf of the service provider.
This is 75.
I annexed there.
This is 75. Where is the next one?
First notification. Therefore, they amended.
Where is the next one?
Page.
Yes, I've got it.
Page 27.
Mr. Bhattacharya, can you
Page
ask your
27.
junior to mail me that he has missed it out? But since it's a notification, I'll take it up. Yes.
Page 27, my lord. From 2015, it is in.
Soft copy of the entry.
No, then can you take out that particular page, a screenshot, 32, and just forward it. Screenshot of that particular page.
32.
Only 32 will do.
That 32 is a previous notification, my lord.
It has to be read along with both the notifications. Second, subsequent regulation has to be read along with that. Without that page 32, I cannot understand. As it is, you have not annexed it. I should dismiss your matter.
Pardon me, my lord.
Yes, Mr. Bhattacharya.
My lord, first point is that, my lord, he is challenging that
The
order has.
focus notice has not been served on him.
Yes, kindly.
Very well. If After all this, I'll ignore that. If you can show me something is there, then I'll say this
Only
is matter.
one sentence of his reply. Kindly see page 35,
No,
madam.
no, issue is different. Issue is under the reverse charge mechanism. This is the notification. The person who is receiving tax has to pay 100% as per this notification. I can see that. Now, how can you call upon him to pay? Simple as that. He is rendering service.
My lord, what happened here, my lord? Kindly appreciate. We have got from the my lord, third party portal that he did not disclose all these things in ST3 return. Now, my lord, this issue has been dealt in the order original, my lord, 4.5.3.
Yes.
And these are applicable provision is there. He
Applicable provision, I understand. But prima facie, if I see there is nothing, applicable provision is always there.
My lord, kindly come to my lord. Page, my lord, 58.
Yeah, have you dealt with this?
Yes, my lord, kindly 4.5.1, kindly 57 onwards, my lord.
4.5.2.
5.1, my lord.
No, does he fall within this? Is he a service provider to a body corporate?
5.4, my lord, 4.5.2. Stated there, my lord, kindly see how he is attracted.
No, question is different. Mr. Bhattacharya, kindly listen to me. He is a service provider, everyone can understand. He is an individual service provider. These two things are admitted. The question that I am asking you, is he providing service to a body corporate? Small question on this. Because if he does so, you see the
body corporate,
officer has extracted this part of the notification which records that if it is provided by the body corporate, 100% is to be by the service receiver. He has recorded that. So only small question, is he supplying to body corporate? If yes, then he is out of it. Whatever returns he may have filed.
It has been 4.5.3, kindly see last two lines.
Yes, show me that. I find.
Is that they have income from body corporate as well as from other than body corporate. Both are there, madam. 4.5.3 last second line. On starting, may I read, my lord? On starting the submitted document, that is work.
Then he ought to have identified which is from body corporate and which is not from body corporate.
He did not file any ST3, suppressing everything there. Had that been the, my lord, disclose everything, my lord, it could be ascertained there.
No, he has given the names of the deductors.
Details has been given. Kindly can't come to the next page, page 59.
Yes.
Page 59, kindly see, my lord. Providing security detective agency on the whole amount. Then, my lord, all such income notice as per such and such, then name of the my lord, deductor has been given there.
He is also confused it. Kindly read it properly. He records that he is required to pay only in respect other than body corporate. He did not say he has to pay for all the 20. He ought to have identified which is body corporate. It is not for you to identify or for me. If your officer considers that this is incorrect, he has to identify which according to him is body corporate. Otherwise, I can identify it. But he can also identify.
Just a minute.
Yes.
In page
I've seen Kolkata Central Division 1.
Page 65 of the writ petition, I provided entire list of the service I provided. Page 65, my lord.
MC Kejriwal Vidyapit.
Kindly look into
MC
the page.
KV Institute Engineering. Monastery of Christ, the King of Discalcet Carmelite Convent.
These are not individuals.
Body
No,
corporate.
these are body corporate.
All body corporate. So all the persons, these are body corporates. So how can he deduct this? Total income is 136, 24, 174. He calculated directly on that. He ought not to have done so. Calculation is on the figure, entire figure.
Yes.
I'll send it back to him. You consider and tell me.
Then, my lord, kindly see, Lord, Sandip Kumar Surana.
Individual.
Ordinary
Individual. I've seen that. There are individuals. He ought to have considered which is individual, which is not. Look, the petitioner has already filed whatever returns he has filed. If assuming he has not filed returns, he cannot club anything. He will only ask for tax only in respect of the portion which he is entitled to seek, not from it. The others have already given it. So I'll send it back to him. Unless you share, his reasoning is 4.5, 4.6 and 4.7. What happened? He has suppressed. If he has suppressed, what will happen? He, a proper officer, is there to find out the suppression. He is not moving a writ petition. He is not moving an equitable jurisdiction. After all, a statutory remedy has been provided. You cannot deduct anything more than, not deduct, demand anything more than the statute recognizes in law. So, statute recognizes for body corporate 0% payment. For these persons. For others, 15% payment. He could not have charged 15%, no, 15% from all these persons. Admittedly, there are body corporate.
My lord, I provided the entire list. I never suppressed anything in the department.
Why did you not pay for Vikash Agarwal?
I already paid. They residual amount, they entire charge 100% on me.
Prima facie, the order is bad.
Well, may I come back, my lord?
I think you should come back.
May I come back, my lord?
Why did he do so? Ask him for an explanation. I'll pass an order. No, I'll pass an order that will help you.
Interim order.
What interim?
Stay.
October 24, the order passed. He can't.
Interim stay, my lord.
Come on
Then
the
you
25th.
vacated.
Sir, your petition is not ready. You have failed to disclose page 32 also.
And so cause also.
This is how you file. Challenging the order passed under section Next. Yes, Mr. Roy Choudhury. Who is appearing for the other side?
Mr. Dudoria is appearing. And service affidavit may be kept on record.
এই আগেটা where is your service দিয়েছে আগেটা সার্ভিস দেয়নি তো where is Mr. Banerjee? Mr. Banerjee, where is the service? Affidavit of service is in your pocket.
Service affidavit.
See the effect. What do? You embarrass yourself, A. B. What disservice you do to your client. Where is the affidavit of service? Not prepared.
No, prepared.
Where is that? Yes?
Cannot remember, my lord.
I couldn't follow.
I cannot remember, my lord.
Who is the advocate on record?
Running from last year, no. Matter is running from last.
He lost the affidavit of service.
No, I cannot remember it, but when they asked me, I supplied the petition 4 times. Both the
Everyone, you represent everyone, Mr. Everyone is represented.
Yes.
তাহলে একটা উপরে or লিখে দাও. Since all the parties are represented in court today, since the respondents are represented in court today, the matter is taken up for consideration without the affidavit of service. First line.
My lord, I have filed my affidavit of service as well.
Question is not, it is understood that you have to have your affidavit of service. You can't lose it. Can't lose pages, missing pages. Affidavit of service is not there. What is, after all, we are responsible for this. This institution is coming down. Look at the standard. Yes, madam.
May I please your lordship? My lord, I am challenging the assessment order for the assessment year 2019-20 on 2 grounds. The first ground is a much agitated ground before my lord, which is pending before the Supreme Court. That is the jurisdiction of the jurisdictional assessing officer and the faceless assessor.
Second ground.
And the second ground is that the order under section 148AD is passed without, is barred by limitation. That on these twofold prayer, my lord, I am before my lord.
After the order has been passed.
But if the order under 148AD is barred by limitation.
Prefer an appeal. I'll give you that liberty.
My lord,
And
it
this
is-
issue will be considered.
If it is barred by
This
limitation,
issue
my
will,
lord, then
limitation also point can be considered. But today, after an order has been passed, I will not.
my lord, if it is barred
Why
by
was
limitation,
it
my lord.
when it was barred? You knew when it was barred. Why did you not approach the court, madam?
My lord, it has come at a very belated stage.
Yes, so
my
I'll
lord,
give you
on
that
the-
leave. I'll give you the benefit. So since you have approached, otherwise I would not have given you that leave. Since you have approached, I'll give. Otherwise, it would have been said that you have given up the point. You can still waive. You can still. Then I'll keep it open. You have not waived your right.
My
You
lord,
have challenged
with
it.
regard to the first point, which is pending before the Supreme Court, in a recent matter also, my lord.
What has happened to the matter in the Supreme Court? I'll record that. If any,
Pending, my lord. It is still pending.
you get benefit of that.
It is still pending, my lord. So this is the order which was
Get the
passed
benefit of that.
by my lord, in another matter.
So I kept it pending.
Yes, my lord had passed an interim order also in this matter.
No. Facts may be different. The order has been passed. Yes.
Yes, that I had come at a very, very early stage, challenging the notice itself.
Whenever you come challenging the notice, I've entertained, irrespective of other courts already have taken steps. What I will do this, I will grant you liberty so far as the question of the first issue is concerned. So I'll keep the writ petition pending on that first issue. I'll grant her leave to file
My lord, then
Pe-
the entire,
I cannot at this stage entertain this.
my lord, if the 148 AD order is barred by limitation,
Everything
then
will
the
go.
subsequent
I'll keep
order
it
is
open.
also barred by limitation.
Very well. I'll keep it open. I'll keep it open. I'll keep it open. So I'll protect you there.
Assessment
Protect
in
you there.
1920, an order was
Challenging the order passed under section 147.
My lord will note the dates, my lord. First, my lord will come to page 64. which is the order under section 148A, capital D. My lord will note the date of the order is 6th April 2023.
Yes.
6th April 2023. My lord comes to the previous page. Page 63.
Yes.
Initially, my lord, to cut short the matter, notice under 148AB was issued.
This is for assessment year 1920.
1920. Yes, why I'm saying so? 6 years. The order has been passed beyond the period of limitation. My lord will see that the time to file reply was extended till 27th March 2023. My lord, section 149(1) proviso
Yes.
says
the time limit. Yes.
yes,
Extend-
7 days.
Not 7 days.
Yes, my lord.
একবার দেখে এটা দাও তো ইনকাম ট্যাক্স অ্যাক্ট
My lord, I will first
The
place
paper.
the 2022 Act and also the 23 Act. 2022? No, 2022.
Yes, madam.
Yes. My lord, first comes to the 2022 Act. 23 Act also embodies the same thing, but in the 23 Act is the 5th and 6th proviso, and in the 22 Act is the 2nd and 3rd proviso
Or 148.
of 149.
140, yes, 149.
149, time limit for notice. This?
Yes.
Yes. So, my lord.
Place it, place it.
Yes. My lord, on the 2022 Act,
Yes.
the third proviso is provided also for the purposes of computing the period of limitation as per this section, the time extended or extended time allowed to the assessee as per show cause notice issued under B of section 148A or the period during which the proceeding under 148A is stayed by an order of injunction or any court shall be excluded. Next proviso, provided also where immediately after the exclusion of the period referred to in the immediately preceding proviso, the period of limitation available to the assessing officer for passing the order under clause D of section 148A is less than 7 days, such remaining period shall be extended to 7 days and the period of limitation under the subsection shall be deemed to be extended accordingly.
Yes.
My lord, here the first notice was issued under section 148B.
Yes.
Was on 24th February 2023.
Yes.
24th February 2023. My lord, ultimately the time to file is extended till 27th March 2023.
Yes. It has been passed on 5th April. Yes.
6th April.
5th April.
No, 5th April is the authority approval date.
6th April.
6th April.
6th April.
Yes. So 27th April.
1 month.
7 days.
7 days, my lord.
27th February. February, no, March.
March.
7 days. 8, 9, 10.
3rd April.
Where is that? From where are you saying it has been extended?
My lord comes to page 63.
Yes.
27th March, you have received the document. On 20th March 2023, you are requested to furnish your submission, if any, by 27th March 2023.
So 27th will be excluded.
Up to then from 27th, 7 days.
It will be excluded.
Yes. If it is excluded, then it will be
7 days.
7 days.
It's less than 7 days. So limitation was expiring less than 7 days?
Yes, then it is extended by 7 days.
No. Let's come to the language once again.
Last date is 6th April.
First of all, this period will be excluded.
Yes. Period is excluded, madam.
So this period will be excluded. That
No.
means I'll get another more time.
So period to file extended.
Still,
I'll get
the
more time.
period which is extended is
P
up
to
to 27th.
P to C is excluded.
Yes. Then, my lord, from 27th March to to 7 days, my lord.
Of how many days period was given to you for granting
My
reply?
lord, up to 27th March 2020.
From which date?
My lord, from 20th March 2023, it was extended time to time. And
No, time to time, that is very important. Show me.
yes,
What was the extension granted? B, where is the B notice?
yes, my lord, first notice at page 34,
Yes.
24th February 2023. My
This is
lord,
B.
A.
What?
148 AA to.
AB.
AB notice, it is
AB.
My lord, then 148B notice, another.
Wait. Now you file reply on.
My lord, the time was given till 27th March. Finally.
You file reply on 1st of March and seek for extension.
I sought
So
for
this 1 month time is there.
This has been extended till 27th.
So it will stand excluded. Previous proviso. Show me which book are you reading?
My lord, I'm reading from the 20th to
Very well, I have the 23rd. এখানে দেখো তো 22 সালের বইটা দেখো তো ওর কাছে ওইটাকে দাও আরে মিস রয় চৌধুরীর কাছে দাও এখান থেকে বের করো এটা বের করো 22 সালেরটা বের করো 22 সাল ইয়েস ম্যাডাম
No, 23 and 22, it is almost the
no
same. It is the
madam
same.
calmly wait I'll just
23, it has become 5th and 6th.
there are two provisos madam.
Yes.
Now the first proviso say first, second, third proviso.
Yes.
For the purpose of computing period of limitation. First, you have to consider this. As per this section, time to extend the time allowed to the SSE to the show cause notice issued under clause B of 148A or so first part to time to give you response is excluded. So 1 month there itself you get. The department gets 1 month there itself.
Madam, perhaps I have misunderstood.
Yes.
May I please?
Provided also slowly. Yes.
Where immediately after the exclusion of the period.
No.
Preceding proviso.
Madam, prior to that. The previous proviso.
Yes, madam.
Third proviso.
Provide also that for the purpose of computing the period of limitation, as per this section, the time extended
or extended time allowed
to the SSE as per show cause notice under section B of section 148A or the period during which the proceeding under this section 148A is stayed by an order of injunction of any court shall be excluded.
So stop here. So first part is you are issued a notice 148A.
Yes, ma'am.
The limitation stops.
Madam.
Why? Because you are given a time to respond or the extended period. Both stands excluded. Both.
I'm in the second limit of the extended period.
So therefore, from first notice is dated 24th February.
Yes.
So from 24th February, this notice, Mr. Dudoria.
This is it is a notice under section 148AA. But
No. When is AB notice?
39.
My lord, AB notice
2nd
is
of March.
No, AB notice is page 39, 2nd March.
Correct. So therefore, very well. That's
Till 13 March.
slowly. So 2nd of March. So the limitation stops to run on 2nd of March. As per this proviso, third proviso.
13th March, because I'm
27th.
Up to 27th.
So there is no limitation
Yes.
from 2nd March to 27th.
Yes.
This period will be excluded and added back.
This period will be
Third proviso is not necessary.
But the third proviso says the order must be passed within the 7 days.
Extended period.
Within 7 days. Again, let us come back again to that. Within 7 days. Provided also that where immediately after exclusion of the period referred. So first exclude it.
Yes.
The period of limitation available to the assessing officer for passing any order under clause D of section 148 is less than 7 days. So after exclusion, if it is less, he will get more 7 days.
Yes.
Want to think over this? Because I will close this issue. If I may be wrong in
My lord,
no, Bari,
perhaps misunderstood, my lord.
madam, I am only trying to understand what the proviso says. Ordinarily, if
For case
multiple
laws on this
provisos
matter.
are there, ordinarily or general, not your special statute.
No.
If multiple provisos are there, then the first proviso will be applied first. Now, if you apply the first proviso, there is an exclusion period which is provided for.
Totally excluded.
To my understanding, the exclusion is 27 days.
Up to 27th March.
So, no. Exclusion is 27 days, 7 days, excluded from the period of limitation. So, on 27th of
13th March and 27th.
correct. So, it's not 27 days. So,
Last,
to minus 2, 25. So, 25 days stands excluded.
25th April.
That 25 days will be available for filing, for giving a notice under section 148 in terms of section 149, third proviso.
My lord, frankly speaking, my lord, I did not find any direct case laws on this point.
No, not the case law. Simple understanding of whatever is there. If you say any, madam, I'm very open on this. I'm ready and willing to accept your interpretation, provided you give me a plausible one.
That I have no doubt, my lord. This
So you give me a plausible interpretation, I will. Case law is not necessary for me to be guided on this.
No. I'm saying that this is a very new point. I did not find any reflection to
Actually, let us read once again.
even to, my lord, cure myself of my misunderstanding.
Actually, let us read once again.
That is what, my, it is relates to my understanding.
Once again, let us read once again together. Now come to section 149 first.
First, my lord.
Time limit for notice. So,
My lord, let me take it.
yes, take.
Point open or open?
No, this I'll not keep open, madam. This I will decide it.
This was also decided.
Then my lord gives me.
I will decide this. I will not keep this open now.
Then my lord, it will be extremely beneficial to us. My lord gives me a bit of time, my lord, so that I can again.
In Giriraj commercial, my lord, Justice Nizamuddin decided this.
Decided this?
Yes.
Yes.
Giriraj commercial.
No.
I'm just doing it. Considering fifth and sixth proviso, my lord.
You send it to me on WhatsApp, and then give this order to my lord.
My lord, because considering say fifth and sixth proviso, my lord, that was assessment year 1819. But I'm
whatever the assessment here.
Yes.
WhatsApp.
I'm for
বলবি তো এটা আছে আমি তো কোর্টে এটা রিপোর্টেড নয় তো
customer reported. Lord, may I?
Provided also.
Yes.
As per the section, the time or the extended time allowed to the SSC as per the show cause notice issued under clause B of 148 capital A or period such as that should be issued. That appears on a plain meaning of the sixth proviso under section 149 that in addition to the time available to the assessing officer for the purpose of limitation as per the aforesaid fifth proviso, after 7 days time then.
Pardon. Yes. Yes. পাঠিয়ে দিচ্ছি
এই আমাকে
হ্যাঁ পাঠাচ্ছি এক্ষুনি পাঠাচ্ছি
Madam, just share over.
Yes, yes, I'm sharing. Yes, yes, I'm sharing. Sure.
51.
Praying for not this week, your lordship.
Today. If I don't get it, then contact my officers.
अरे दिए देना काल के नहीं है काल के नहीं है काल के नहीं है
Your lordship for your lordship for item number 51 and 52, praying for not this week, your lordship. Your lordship, Shine is ill, your lordship. Somnath Rai Chaudhary, your lordship. Yes, severe pain in some. 2 weeks. Exactly.
51, 52.
51, 52. No.
I am for the petitioner, my lord.
I am for the respondent, my lord.
And only submission, my lord. My lord, in that case, my lord is missing. Kindly see the 158, 148A, capital D. Income tax. 148A, capital D. The small d, my lord. Capital 148, capital A, small d. From the end of the reply, after filing reply, they will get 1 month. March and 8th of April. 6th April, this time they is saying, my lord, if the within 1 month, March, we have the right time to file, pass the order, end of March. Yes.
An independent court.
No.
Contention. It's an independent court. So therefore, if it is within 7 days, you have to file it on this. If it is within 7 days, limitation period expires, then you have to file it within that extended period of 7 days, not beyond. To that I said you have to apply both the provisos. Yes. And then evaluate. Interesting.
Yes.
That is an interesting and individual. Yes.
In this, this is the matter, I am challenging the adjudication order on the ground of they have not provided me the personal hearing, right? The show cause order itself. Then, they have mechanically passed the adjudication order without considering my reply. In response to the reply, I have filed in response to the show cause order, I have filed a reply. Kindly see page 43, 3-4 pages I will show, but it is apparent from page 43.
See, he has shown me that there are orders. Authorized representative appears and takes up.
No, it is apparent. Maybe that it is independent case, the case to case basis. I cannot.
Which page is the order?
Order is page at page 53 is the order of adjudication. Kindly see before going to the order of adjudication order, kindly come to page 43, DRC 01. That is a show cause notice.
page 43, annexure P5, dated 20th April 2022, April. Well, kindly see, come to page 44. The details of personal hearing and due date to file reply. Date of personal hearing in. Well, I'm saying, coming to that. This is the one point. Well, in response to the DRC 01A, I have filed reply. It is, but kindly come to page 23. Page 23 of my reply. Kindly DRC 01A part B. I filed reply in response to DRC 01A. Minor first manner 01A issued. I have filed a reply. In the order, they're saying that they. But that is also considered. It is the intimation. Although I have filed a reply, 2 replies. He said, I kindly come to page where minor order adjudication. Impugn order. Page 54. Please note that your failure to comply. Yes, ma'am. And last paragraph also in response to. Yes, ma'am. Yes, ma'am. 55.
Show me that you have.
My point is that, my lord, DRC 01, I have did not file in reply. My lord, no, my lord, only why I am saying, my lord, they have in the show cause notice, my lord, they have not provided with the personal hearing. Kindly see that. My lord, this is the notice. Kindly see the notice first. DRC 01. On 20th May.
Kindly come to page 47, last 2 paragraphs. Suppose I can improve on the fact. No, kindly, if you have any, what I've asked him,
yes,
he'll come with all the documents.
I can't help you. This is not on natural justice also, because you can't say that right. Thereafter, I will not give you.
My lord judgment, reported recent judgment one.
Last 2 paragraphs, thereafter, decide. Because may I just place it thereafter. If you have any disagreement against the aforesaid findings and against the above mentioned ascertainment, file your submission along with the following documentary evidence.
Now, nothing filed.
Within stipulated time as
Very bad person.
Supporting documents are not as
even assuming that also, kindly see page 46, where he asked. The taxman reported.
The statute recognizes the right, and these are all statutory multi-tier adjudicatory process. You have to give him this opportunity. The present petition has been filed.
Well, I am denying this judgment, kindly. My lord has passed on. এখানে 21 তারিখে দিচ্ছে 28 তারিখে নোটিশ 21 তারিখে অ্যাপ্লাই 22-20 মানে April 2022 to March 2023. DRC 1 at page, my lord, 43. Page for annexure P5. Tax period April 2022 to March 2023. Page 40.
Conspicuously silent about stuff. Although there is no having regard to the statutory mandate of section 77, right of the petitioner that purpose of section 75(4).
Yes.
Obviously that the officer order statement should be satisfied. By this mode online.
And only
Now we only at liberty to rely on documents.
document only only I'm just doing reply I have filed. No, no. No, my lord. No.
And send an order at law without
My submission is otherwise, my lord. My submission is otherwise, my lord. In response to the DRC 01A, that reply may be considered. My reply has been filed. It is on record. Man, it is a part of the record, my lord. DRC 01A, they have issued. I have filed a reply.
Since the petitioner has not filed any response despite being repeatedly called on.
No, only one notice, but it is wrongly recorded.
Available petitioner to file a response by the proper officer while deciding the matter of fresh. He shall, however, be obliged to afford a personal opportunity and in course of such opportunity, if any documents are placed, he shall consider this.
Only in the order itself, in response to the DRC 01A, yes, man, I have filed.
They will rectify it.
But I have no liability. Being a transporter, I have no liability under the GST Act. If you consider my reply in response to the DRC 01A that I have filed twice, if then there is no yes.
Yes, call the audience.
Grateful. Grateful.
Again, one more application.
My lord, for item number 54 appearing for the petitioners, my lord, I'm being led by Mrs. Rita Mukherjee, my lord. My lord, she just had her knee replacement. So it would, my lord, if it is kept on the month list of August, my lord, it
My lord,
will be applied.
my lord, kindly.
It will.
After all the petition that we can go there. So record this. It will not be fresh anymore. I'm not recording.
My lord, my lord, regarding the item number 55, it makes it. No, no, बोलो order करो और नाम का वो बोलो अभी record करो Union of India नाम दी
Evidence.
Madam, give your name. The Siddiqui appearance. Name order.
My lord, may I permit to mention one matter?
August.
My lord, may I permit to mention one matter? May I grant file the wakalatnama and affidavit of competency? Since, my lord, since the erstwhile advocate has not given till yet, he has not given the NOC. And we have filed one application because of NOC, we are not able to file the application. Fetch the maximum. August 20. Huh? Okay. Erstwhile advocate. Okay. Deeply obliged.
Yes, number to लिखे.
Case number.
No mentioning, my lord. My lord. No, Monday, my lord takes the mentioning, my lord. My lord, that I know.
Original side item number 14.
My lord, I am appearing, my lord, virtually, my lord.
Yes.
Sir,
My lord, what happened in this case, my lord, on 6th April.
Hear me, Mr. Duggar?
Yes, I am hearing, my lord. My lord, on 6th April 2021, a search and seizure took place at my premises, my lord. Thereafter, my lord, cash was seized to the tune of rupees 52 lakhs, my lord. Now, my lord, thereafter, my lord, a statement of the director was taken that 30 lakh was withdrawn from the bank for meeting the expenses in relation to the business. And my lord, balance amount was in relation to undisclosed sale. Thereafter, my lord, what happened? We filed a return.
Couldn't follow. Once again.
My lord, the director's statement was taken. My lord, your lordship, am I audible, my lord?
Yes.
The statement of the director was taken. Director stated that out of 52 lakhs cash seized, 30 lakhs was withdrawn from the bank to meet the expenses in relation to the business. And my lord, balance amount was undisclosed sale. Now, my lord, thereafter, my lord, we offered this amount as an advance tax. It should be adjusted with my liability. This cash, my lord. Now, my lord, thereafter, we filed the return showing this amount adjusted. Now, thereafter, my lord, an assessment was made. And my lord, under section 143(2), and my lord, in that assessment, a demand notice was also issued under section 156, my lord. Now, my lord, after issuance of the demand notice, we found that the amount of cash which we offered as an advance tax was not adjusted. Therefore, my lord, we wrote a letter to the authority that you adjust the amount and refund the balance amount which remains after adjustment. My lord, the officer said tight. Thereafter, we filed this writ petition, my lord. After filing this writ petition, my lord.
How did you pay that?
Well, that cash was seized and lying with the authority. We offered this amount of cash to be considered as an advance tax.
That is seized.
Yes, my lord, they can, my lord. That is a provision, my lord. Now, my lord,
how can it be adjusted?
My lord, there is a provision, my lord, section 132B, my lord.
Yeah,
Kindly
I'll
come. Yes. No, my lord, these are not disputed fact, my lord. What I am submitting.
I'll consider the section.
Yes, my lord. Your lordship may consider, my lord. Yes.
Which section?
Yes. 132B, my lord.
I understand that. 132.
132B, my lord.
Yes.
No, just a minute. Lord, kindly come to 132B3, my lord. First, my lord, kindly come to 132B, subsection 1.
No. Yes.
May I read, my lord? The amount of any the assets seized under section 132. Cash was seized, my lord, under section 132. It is an admitted. Requisition under section 132A may be dealt. 132B, my lord, your lordship is getting 132B. May be dealt with in the following manner, namely, the amount of any existing liability under this Act, the Wealth Tax Act, the Expenditure Act, Gift Tax Act, and the Black Money Act.
Read that on completion of assessment or reassessment or recomputation.
And now, my lord, kindly see 132B1 to subsection 2, subclause 2. If the assets consist solely of money, partly of money.
Mr. Dugar, you have to read proviso first.
Yes, that advance tax, my lord, has been excluded.
No, provided where the person concerned makes an application to the assessing officer within 30 days from the end of the month in which the asset was seized for release of assets, and the nature and source of acquisition of any such asset is explained.
Yes, my lord. That is about the, my lord, release of the entire money. Release of the entire money. What I am saying, that a part of the amount may be adjusted with my liability, my lord, existing liability. That is, my lord, returned liability. Now, my lord, kindly see 132B3. Any proceeds or any assets or proceeds thereof which remains after the liability is referred to in clause 1 of subsection 1 are discharged shall be forthwith made over or paid to the persons from whose custody the assets were seized.
Yes.
Thereafter, my lord, there is a provision for interest also, my lord, that is under subsection 4, subclause B, A and B, my lord. Now, my lord, we wrote the letter to the authorities for refund of this money after adjustment of the taxes with the liability, my lord. Now, my lord, after filing this writ petition, the authorities, my lord, has issued the check for the balance amount after adjusting all the liabilities, my lord. Now, my lord, so far as interest is concerned, my lord, they have not considered, and my lord, they have not, my lord, taken any decision. So, my innocuous prayer before your lordship is, my lord, that I have written a letter that may be considered by the authority, my lord, insofar as the interest is concerned.
120 days have expired.
Yes, my lord, long way back.
Mr. Then you are liable to pay interest also.
But, so far as the documents which are seized, my lord, the proviso says that within one month he has to make an application, and that application, I don't know whether it is paid or not. He said, my lord, that I don't know.
Independent of that application,
my lord, my submission may be recorded.
Assets and other monies may be applied for discharge. May. It is for discretion, your discretion. Applied for discharge. Now, have you applied it? You have not applied. Money is there.
But money has been seized.
Seized for a particular assessment year?
Yes.
Correct. In a particular assessment year, the seizure cannot be open-ended. Seizure has to be for a particular assessment year. Now, has the reassessment been completed for the particular assessment year?
Yes, madam.
Now, 132B says where yes, correct. Where it says that where the amount it may be dealt with the amount of any existing liability under the Act or different acts, and the amount of liability determined on completion of assessment or reassessment.
Yes.
That is the line. He's right. He did not apply for, he could not explain. Fair enough.
Yes, yes.
Could not explain. Will you not apply it? It cannot be confiscated. Can the money be confiscated? Negotiable instrument be confiscated? Any provision for that?
There is no.
Yes, yes, Mr. Sharma, anything? Yes, yes. Yes, yes. Yes. On, he has to show the source.
Then the department can keep the money. But
That is different. That is different.
after assessment,
Here his case is, if I heard him correctly, what Mr. Dugga said, that X amount was said to be withdrawn for health issues and Y amount as disclosed as undisclosed sale. They have
Yes.
admitted that as undisclosed. So they have shown a what do you call a source, undisclosed sale. So the consequence is there. That consequence will follow.
And they have accepted.
And today, that is why I asked. Today, the assessment order has been passed.
Yes.
So from the assessment order, what does it say on undisclosed sale?
My lord, the exact amount which I have shown in my return has been accepted, my lord. That return. My lord, kindly see page number.
Even after the search and seizure?
No. After the search and seizure, I filed the return because the search and seizure took place in between the year, my lord. So return has to be filed after the end of the year. My lord, kindly come to page number. My lord, may I explain my case, my lord?
Technically, Mr. Duggar.
Yes, my lord.
Going through your search and seizure, they
My lord,
must
kindly
have this on the portal.
my lord, kindly come to page 18, my lord.
Yes.
I have disclosed my total income at, my lord, rupees 72,99,430. Lordship got it. Now, my lord, kindly come to next page, my lord, the assessment order. Page number, my lord, kindly come directly to page 20, my lord. Here, authority considered that out of 52 lakhs, my lord.
Mr. Dudoria, you have accepted this.
And my lord, now kindly consider, my lord, page 22.
Sale of its proprietorship concern.
Now, my lord, kindly see page 22.
You have acknowledged it.
Total income assessed, my lord, it is exactly same. Page 22, my lord.
Whatever. So you have taken into consideration. Apply it. Any demand is there?
Demand was there, my lord. Thereafter, they adjusted that amount because after filing this writ petition, my lord, they have issued the refund amount. They have issued the refund of the principal. No, refund of the principal sum, my lord. But interest they have not, my lord, refunded. So, my lord, my prayer is to ask them to consider my prayer for interest, my lord.
No, why interest? If you are entitled to interest, you write a letter to them.
I have written, my lord. They will consider, my lord. That direction may be given, my lord. They will consider my application, my lord.
You have already got the refund.
Refund principal sum, they, my lord, today they were today they were supposed to give, but since the hearing
document, Mr. Dudoria is at a loss. He does not know anything on this.
That's why, my lord, at the outset I said, my lord, it is an admitted fact. They have refunded the principal sum, my lord.
Did not say. Now you are saying that.
No, my lord. When I was saying, my lord, then your lordship said that.
Where is the communication?
Communication, my lord. Then, my lord, kindly fix a date, my lord.
No, not day. Tomorrow.
Tomorrow, my lord.
I heard you. Tomorrow, same thing. I'm not recording any order. You take instructions. Can you come back tomorrow? Very well. Having heard Mr. Duggar, learned advocate representing the petitioner, I'm of the view that Mr. Dudoria, learned advocate representing the department, income tax department, should take appropriate instructions in the matter. In view thereof, let this matter stand adjourned and appear in the same heading on third. Third means morning. Third means morning.
Yes.
Third means morning, in the morning.
Yes.
Please, your lordship. Lordship, a very a very sui generis situation, my lords. Will kindly just allow me to trouble my lords for 2 minutes. The petitioner is a Samgha, socio-economic body, lordship. They have followers. It's a Samgha. Now,
Samba.
lordship, like a Sangh.
Sangh,
Like a
Sangh.
They, Anand Mark,
very
my lords. Anand Mark Sangh.
petitioner is Anandamar.
Yes.
I see.
Now, my lords, way back in 2005, there was a dissident group. A lot of suits between
It's recognized.
recognized by the Supreme Court, my lords. We have orders, but that's not the
No, I want to know from you.
lordship. Yes, lordship. It's recognized. It's recognized as Supreme Court order treating us as minority. My lords, I'm led by
Yes.
Chatur.
Yes, yes.
Led by Mr. Chatur.
Anand Mark is a social spiritual organization.
Yeah, that's why when
And
we were young, this organization were in the headlines for anyway for different reasons though.
For notorious reasons.
No,
but
not even. That's why I'm asked.
that is again disputed.
Yes, past.
85
That's all
Supreme
in the
Court-
past.
85 Supreme Court recognizes us as a religious denomination.
Fine.
And Anand Mark Pracharak Sangh, my lord, is a
Are you a registered body?
it's a registered society.
So registered, it was throughout a registered society.
It was throughout a registered society.
So in 80s, that issue came up and thereafter that judgment was delivered by the Honorable Supreme Court.
That is with regard to the sect. One is a religion, and the cause of the religion is taken up by the society. Now, programs are organized under the aegis of the society. The society, it helps in furthering the cause of the sect. Now, it's a society registered under the Societies Registration Act. But in the year 2003, particular group of members, they splintered away and they constituted body, said that we are now the duly constituted body, give us the charge of the governing body. Give us the charge of the governing body. The existing governing body did not. They filed a suit. But in the injunction, the status as it continues is that the civil court has said that the present dispensation should not be disturbed. There is no reason why the charge should be handed over to the newly constituted alleged body. Now, for furthering the cause of disseminating anti-organizational activities, these persons were expelled. Their expulsion was also challenged. Now, I pause here for a moment because beyond this is not relevant for our present purpose. But the Anand Mark is given a PAN card. The login IDs belong to the office bearers of the principal mainstream Anand Mark. It was filing returns. Clandestinely, somehow the splinter group, it got hold of the login details and thereby gained access to the returns that we were filing, and they were revising them. They were revising them. This was, my lord, when the filing were done.
Who was filing the returns?
We were filing the
So
returns.
who was revising them?
The dissent group. And this happened when, my lord, this was being done, my lord, offline.
No,
Now-
Mr. Chaudhary, kindly. Very well. DSC was not there.
My lord?
The signature was not there.
Yes.
The DSC was not there at the point of time. Fair enough. What was the procedure? Physically sign it and then send it. Physically sign it and then forward it to the relevant office, either by post or whichever means. I see. So that is how you used to file the returns. And they used to apply for rectification.
Rectification. This continued because they had the login details. They got a PAN card with identical details issued by the income tax department.
I see. Are they party here, first of all?
No, not required. Not required. I have come up against a notice.
They have been issued a PAN card with identical details. So therefore, if they have been issued a PAN card, you may be separate, but in the eyes of the income tax, that person has to be notified.
As if my lord desires, so my lord kindly hears me, my lord, what
Yes, yes, I'll hear you. I'll hear you.
the shoe is pinching elsewhere.
Acha.
Now, my lord, when a complaint, my lord, was lodged by both of us as to not to permit them, they said not to permit us to file the returns. Both said that it may not reflect the true and correct picture of the returns which should be filed by the society. The PAN card was deactivated.
Your PAN or both PANs?
But the PAN is, I would say, one, bearing one detail with same number. So this deactivation was challenged.
So there is only one PAN.
One PAN, two cards.
Card may be 100 cards may be issued. Same number with same credentials or credentials different.
I am extremely grateful. My lord used the word credentials. I was not about to use this. This credential belongs to a person.
Are different for the two cards.
Yes. No. It belongs to a person called Harishanand Avatul. So this is a name and his phone number that is unique to this credential.
Correct. So your card bears credentials of a particular gentleman, although it is at no. In trust, in case of trust, it is the name of the society which will feature. Unlike an individual, where the name of the individual will feature and with a photograph. In case of society, there is no photograph. He'll correct me if whatever it is. Yes. Yes, certainly I'm aware of this. So the society's name will be there without the photograph. Individual's name with the photograph.
When the card is applied for, my lord, an initial credentials are to be provided with.
That is at the background. From the card you can't make out.
But I cannot.
Today, what do you want?
Today,
this card has been deactivated.
It has been deactivated. My lord, this would be relevant, my lord, for some purpose. I would come to that if required.
So you are unable to file your returns.
I am unable to file my returns. I came up before this honorable court. This 2019, this honorable court directed the department to ascertain on the basis of orders passed by civil court and the documents to be produced by the respective parties and arrive at a conclusion as to who is entitled to use these credentials and login ID to file the returns.
Yes.
That is, my lord, an order, my lord, which is at page 70. I shall, my lord, come to that. My lord, the department, my lord, considers and, my lord, passes an order but does not decide. Says that an advice.
How can the department decide? You are asking the civil court's job to be done by the department. Why will the department decide?
Not me.
You have approached the court. You have succeeded in getting the order. You file a suit and establish your right.
One of those unusual situations when I was successful in getting an order, was not accepted by all the parties. Income tax said that yes, we will do it. The assessing officer was directed. The assessing officer says that an advice is being sought for from the ministry, and my lord, this was at that stage it was kept. I came up again before this honorable court. I am unable to file my returns. I filed the second writ petition. My whole idea is, my lord, not that I want to prevent the other group from filing a return.
Have you filed any suit?
Yes.
Where is your suit? What is the priors in the plaint? That
now, I am facing a suit.
Have you filed a counterclaim in that suit?
Not required. Not required.
What is the prayer in the suit?
The prayer in the other suit is that they are the duly constituted governing body entitled to take the charge.
And you are not.
And
you are not. Have they said and you are not?
No.
Then
now kindly see, my lord. My lord, kindly, my lord, this is a stage of the suit. I shall show the orders passed by
so
the
they sought for a declaration.
They sought for a declaration.
And consequential relief which was not granted, declaration pending.
Pending.
There is no declaration pending by you.
No declaration pending, but in the injunction application which came up until this honorable court, order is that the present dispensation should not be disturbed from functioning. There is no reason to alter the management and affairs of the society.
How do I know that you are in the management and affairs?
the cause title of the suit would indicate that.
Unless, that is why I asked you, what is the prayer, Mr. Chaudhary? You are from the
Yes, yes.
unless the declaration is that I am entitled to and they are not. So then the question is a negative declaration you cannot seek. Positive declaration they are entitled to. In that suit, they have sought for an injunction restraining you. Now the court said, no, I'm not going to grant you any relief. There is no necessity for changing the status quo as prevailing. But the court did not give any blessings to you, saying that you are authorized to represent also.
Yes, yes. That is
there is no suit for that purpose. How can the court grant any relief, Mr. Chaudhary? There is no declaration sought for, no final relief is there. How can a temporary relief be granted?
Could we, Milord, for the moment, Milord, keep this aside and only, Milord, rely on the findings of the court to the extent that it inures benefit to the respective
Very well.
parties?
Today, what they have done, what the department has done.
Yes. Now they have deactivated. I filed the second writ petition. Second writ petition and order is passed. Milord, kindly look into that order. I'll start from
149.
page 84.
Yes.
Milord, kindly sees. This is the second round.
Yes.
This is the second round of writ.
Same 167, anything, same order. Yes.
It is to be noted that in the first round, this court on November 27 had passed an order directing the officer concerned to decide upon the issue as to who was entitled to file the return before the income tax authorities. Arguments have been heard by this court. It appears that for interim period, while civil court decides the issue of management of the society, an order is required to be passed with reference to filing of returns by both the groups before the income tax authorities.
Civil court has to pass this order.
Civil court is to pass what order?
Whatever order has to be passed by the civil court.
Kindly cease. Mr. Chaudhary, so and so, counsel appearing on behalf of the income tax department is directed to take instructions in this matter as to whether it would be possible for income tax department to issue 2 PAN cards and accept 2 returns from both the dissenting factions. This was the direction. The writ petition is still pending. In respect, it is appearing in my law.
Ask them if they are ready and willing to issue 2 PAN cards.
Now, may I? Now, during the pendency of this writ petition, when subsequent notices were issued for the later period, I have filed CAN application, which is again, pending and it's appearing in my lord's combined list. Now, a notice is issued to me, under 148A1, which is at page 86. I reply to this notice. I express my predicament that I am unable to file my returns because you have deactivated. Now, kindly see, if I am on live support system, can I be asked to walk?
Everybody, please understand the entire issue that you are seeking redressal from a court exercising jurisdiction under Article 226 is required to be done by a civil court, including interim protection.
Look,
you have to approach the civil court, get this order. This court cannot pass this order.
Look, I shall, kindly permit me to
I will
say
clarify the entire position and permit you to approach the civil court with protection that the civil court can undo whatever in the meantime has gone wrong.
So kindly then,
if you are not entitled to represent, why can I give you the blessings to represent?
Yes.
How will this court know that whether you are entitled to represent? Nothing between you. So your client, Mr.
Yes, yes. Now, I shall show the order. And then
what is the relief? How can he challenge, first of all? Because the issue of maintainability is there. And why will this court enter into all these things today without you being blessed with any? I will keep it pending. You go and apply before the civil court. I'll pass a 2-line order permitting you.
Kindly come to the order passed by the civil court.
Yes.
But this is page 39.
Yes.
Lord, kindly see, this is on an appeal filed by the plaintiffs. Kindly see the array of parties.
39.
Page 39. 39.
Yes.
So kindly see the array of parties. But this is kindly see serial number 1. Bhavesh Acharya, Bhaveshanand Avadut. and others, they are the plaintiffs. And kindly sees the defendant, Acharya Raghunath Prasad. This is suit of 2003. Raghunath Prasad is now deceased, and the successor in office of the secretary and president have been substituted in the suit. Now, kindly sees, my lord, page 40. Page 40. Kindly sees the second paragraph starting with the words, the fact of the case in brief is that.
No, you come to the direction. For the entire order, you need not please.
Kindly, I shall read only 6 lines.
Now let me consider the misappeal. Come to that stage.
Kindly sees the facts, my lord. What are the facts, my lord? Kindly sees only 6 lines. Only 6 lines at page 40.
The order is again repeated. This is repeated in paragraph page 42. Huh?
As my lord. So the last paragraphs.
Oh. Yes, yes.
May I continue?
Yes, yes.
Page 42, last paragraph. In this case, the plaintiff appellants prayed for injunction restraining the defendants from functioning as a president, general secretary of the above named Sangh, who are looking after the administration and functioning smoothly. There is no specific allegations against them that the mode of functioning administrating of the Sangh. If that be the position, then why the court will injunct them from smoothly functioning and administering the Sangh? There is no necessity to make further chaos in the committee. So I think that the existing governing body will remain as it is on this day. According to me, existing governing body should not be injuncted. Otherwise, the whole administration, law and order will be paralyzed. The interest of all members and the noble object, if any, would be frustrated. So I think that the existing governing body will remain as it is and they will function as functioning now. They should not be disturbed for the sake of peaceful administration of the present. So, my lord, this being, my lord, the state of affairs, my lord, I remain to be in the governing body ever since 2003. That is an admitted position.
Sir, this is a miscellaneous appeal.
Arising out of the suit.
Yes.
The suit is pending.
Injunction, refusal to pass injunction order, whatever. It's very clear.
With a definite fund, kindly see.
In this case, the plaintiffs have prayed for injunction restraining defendants from functioning as president, general secretary, above Sangha, who are looking after the administration functioning smoothly. There is no specific allegation at them. The mode of functioning is such and such. According to me, this is all interim.
Yes. I am again. I say, to what purpose? To what purpose an interim order is passed?
Now, where have you made them parties in this petition? Why have you not made them parties in this petition?
My grievance is, kindly.
No, you cannot get any order without their presence.
I shall implead, but kindly see,
You first implead and come back. Otherwise, I will not grant any relief. This cannot be, Mr. Chaudhary.
No. Today, why I have come before my lord? That despite this despite this order, they could not decide. They deactivated. I came before this honorable court. This honorable court directed them to decide. They could not decide. I came in the second round. In the second round, the court directed them to take instructions. They could not come back with instructions. The repetition is pending. Now 148 capital A and now, my lord, 148 capital A3. That they find that appropriate situation has arisen where, my lord, the proceeding should be initiated. I have come up.
I do not even know who has filed the petition. Whether this person is at all entitled to. Where is your power? देखिए ओखाने competency देखिए competency competency.
He's a general secretary.
Was he a general secretary when the order was passed by the society? By injunction order was passed? Was he then a general secretary?
That man has died.
No, it's not so easy, sir. Injunction is the court said that I'm not going to change that situation. Now, whether he has the competence or not, there are lots of issues.
The successors, kindly sees. This is, we are talking about 22 years ago. The man has died.
So, therefore, what happened to the suit?
Suit is pending. Despite 6 orders directing that the matter should be disposed of within a period.
After all, this is a society. How are you controlling your businesses? There must be election is there. What does the bylaw say?
There is election, and the election of this segment,
No,
this
no,
set.
please serve and come. Please serve and come. Unless you,
I kindly, my lord, again, my lord, I am not, my lord, for the moment resisting, my lord, what is falling from my lord.
no, no, no. I
for
am
a
not saying I'll pass an order in that case. I am not asking you to make them a party. If you are ready and willing, you do it. Otherwise, I'll pass an order. I am this court is competent to pass appropriate orders. Choice is yours. What we will do.
Only hears me, my lord, for one moment, that this deactivated card would not have permitted me to file the return. The card, whether it is for me.
Then make up your mind. Are you going to serve or not? If you do not, then I will pass appropriate orders. This is a choice for you. Don't say that the court wants. The court does not want anything. Sir, you are a senior advocate, sir. You should be aware in the fitness of things what should be done. If you consider that in the fitness of things it is not necessary, don't do it. Then the court will pass an order. But if you consider it is necessary, do so. Choice is yours. You do not need to say yes to the court, whatever the court says.
No,
I will pass an order in that case.
Yes, yes. Well, if I'm challenging, my lord, an order passed against me,
Yes.
then, my lord, I am entitled, my lord, to move this application without implementing any defect.
Very well. Ashwin.
My lord would hear me.
So you made up your mind. You said so. I'll pass an order. I am giving you the choice, Mr. Chaudhary.
Oh, my lord is giving me the choice today.
Yes.
But
Then I have to come back tomorrow. You see,
in the meantime, my lord, the whole
tomorrow, I'll continue with this tomorrow. Continuing matter. Tomorrow, as I have to rise.
Yes, yes.
Tomorrow. Continuing matter, first matter tomorrow.
No order today.
Then I have to dictate the order. There is not much time to dictate. I'll come back tomorrow and pass the order. You tell me tomorrow what is your choice, and I'll
I'm grateful. I'm grateful. I'll get some time.
Yes. Consider and come back.